Special board meeting to order. If you will all join me with beginning with the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ann, can you do a roll call attendance, please?
Sure can. Bartlett?
Yes.
Cook?
Yes.
S. Cortade?
Here.
Lyle?
Here.
M. Cortade?
Here.
Friend?
Yes.
It's noted that Walters is absent and excused.
Let's see, on the agenda, does anybody, looking at the 4 items on our agenda, have a conflict of interest? And those 4 items are short-term rentals, the bottomland conveyance for 2 properties on US 31 North, East Bay Ambulance, and job description. Any conflict of interest? Okay, seeing none, approval of the agenda. With that, I would like to switch the bottomland conveyance and the short-term rentals. I had forgotten when I drafted this up that I had mentioned that I would put that first due to some childcare issues. Okay, is there a motion for the agenda?
Make a motion to approve the agenda with the switch of 1 and 2.
Support.
Okay, motion by Bartlett, support by S. Cortade. All those in favor indicate by saying aye.
Aye.
Aye. Opposed by no? Okay, we'll move forward with that agenda. This is the opportunity for public comment. We will take public comment during the item for short-term rentals. So this would be public comment for anything else on the agenda or anything else in general. Again, we will take public comment during the item for short-term rentals. Is there any public comment this evening? Sure. Step up to the podium and introduce yourself.
Good evening. My name is Ken Freimeyer. I live at 914 Mitchell Street, and I have 2 short-term rentals, one across the street from me and one right next to me. And everything is on about 50-foot lots.
Yeah, Mr. Freimeyer, you're going to have the opportunity to do public comment during that agenda item.
I'm sorry, I misunderstood you. I thought you just said you could talk about it.
No, yeah, well, but short-term rentals will be specifically during that item.
Okay.
So we'll just wait to get through the first item. Anything else? The other 3 items or something completely different? Hello, Mr. Treadwell, how are you?
Pretty good. Mitchell Treadwell, 620 West 7th Street, Traverse City. Speaking about the groundskeeper and park maintenance position, while I understand that it can be fiscally advantageous in the short term to have certain groundskeeping services go to contractors rather than handling them by township employees, I would like to encourage you to try to keep as much of those duties in-house as possible, because, speaking as somebody that has done landscaping work and similar groundskeeping, including in East Bay Township for the DNR, the more you keep that within public control, the more you can ensure that if somebody has a complaint about a park, that you can get that addressed in a timely fashion. If, say, the grass isn't getting mowed or there's a tree that's coming down, if your park staff is responsible for as much of those park maintenance duties as possible, then you are the one that is responsible for that, and you can address that in a responsive and timely manner. Thank you.
Thank you, Mitch. Any other public comment? Okay, I did forget to have Ann go through the rules for public comment, so Ann, hold me to it, and we will do it before the next opportunity for public comment. Okay, with that, we have the East Bay of Grand Traverse Bay bottomland conveyance for properties 2155 US 31 North and 1773 US 31 North. You do have on your desk as well, you have information from the applicant as well as public communication that came in for that. And this starts in your packet if someone has their Hands on the page?
77.
77. Thank you. Starts on page 77 in the packet. And so with this, I'll ask if the applicant is here in attendance. TC Water Sports, hi, how are you?
Good, how are you?
Good. Would you like to go through your request? Let me just, while I say that, let me just preface really quickly. The board has in their packet the March 14th email from TC Water Sports explaining why their request was before us. And then for each property, you have what was approved on the respective date of what was approved earlier. 1773 was approved in March of 2021, and 2155 was approved in October of 2021. You also have the new map that's sought. You have both the resolution for today, if the board chooses, and the previous resolution. And then, of course, I listed the other online packets that had statute in them and all other sorts of information. And you are Sabori?
Saburi Boyer with TC Water Sports.
Okay, and we do have your handout here.
And it dawned on me after I sent you that they're a little bit small and maybe hard to read, so I've reprinted a slightly larger
Okay.
version.
Okay,
I can pass those out for you here.
and the maps we do have in the packet as well, so.
No, I can see it here.
Okay, go ahead.
So in 2021, we applied in early winter for a bottomlands conveyance at 1773 US 31 North, which is the Sugar Beach Resort property. We obtained a resolution of approval on March 8th of 2021, and following that East Bay Township process, we did apply for and receive dock permitting from Eagle. We received that in August of 2021, and then it was revised in July of '22. Eagle has requested that the approved dock permit match up with the township resolution, and the boundaries of those lease areas were not exactly the same. The reasoning for that is during this process, we had a public comment period, we had a rather robust public hearing, and so after receiving our approval from East Bay Township, Eagle asked us to make some changes to the dock to accommodate some of the needs of our neighbors and the comments that were made. And so that's why you have us here before you today asking for essentially a new bottomlands conveyance approval, is because the dock process evolved and the permit changed. Both docks are approximately the same size. The bottomland area is slightly larger in the newer version. And that version was the version that was acknowledged back in February of this year. Unfortunately, we need an approval or denial of the resolution, not an acknowledgement. So Eagle was not satisfied with the outcome of that meeting, and they need to have an approved conveyance in order to finish processing this permit.
Okay, is there anything you'd like to cover on the additional property too before we?
On the 2155 property, there was a request by Eagle to permit a couple of buoys that we'd added. They're just safety navigation buoys, but Eagle said that they wanted to make sure we had a bottomland area that was large enough to encompass those buoys as part of the permit process. So that one also has an expanded area. I believe the dock drawing is the same. It's just a slightly larger lease area.
Okay. And you have, what you handed out was what's in the printout, just a larger version. And this is respect to the Sugar Beach property?
Correct.
Okay. All right, and the board has had those in their packet as well. Are there any questions regarding the 1773 property from the board? Go ahead, Glenn.
I got some information from one of the residents about the bottom land. And apparently, we're in litigation in court,
Not about the bottom land,
not about what?
not about the bottom land. So,
About allowing it, wasn't it?
not to my knowledge. So, Sabori or Claire may be able to shed some light on this too, but my understanding is the litigation is, so the ZBA declared the activity not an accessory use.
Okay.
That went to court, and Judge Elsenheimer said, I need more clarification or findings for your findings of fact. And so that was sent back to the ZBA. They confirmed their decision on that they felt it was not an accessory use. And at that point, it was a new decision. It wasn't like just a review of the previous one, it was a new decision. And so TC Water Sports has engaged in appealing that decision. However, TC Water Sports also at the same time does have an approved site plan review to operate as well. So I'm getting some head nods from Claire and PT. If you guys might just step up, and Sabori, if you might just let them take the stage here for a second. You can have a seat in that middle seat there if you want. Was that an accurate portrayal, and do you have any further information?
Nope, I think that is accurate. So as it stands right now, the township has approved TC Water Sports to operate under the site plan review that the Planning Commission approved for the Sugar Beach property. So this bottomlands conveyance would be consistent with their current site plan approval.
So Glenn, even if TC Water Sports is not successful in appealing that decision, they still have the site plan review and can operate there. So they would still be looking to do the dock and the conveyance, correct?
Correct, yeah.
I guess I'm confused on why we're even in court over it. I think
Yeah, it's them appealing that they're not considered an accessory use. I guess one might say, why would they do that if they already have an approved site plan review? I can't answer that for you because I'm not the one who is appealing it. But I'm imagining that there are some reasons that they have. I don't know. But it is with respect to whether they're an accessory use, not the bottomland conveyance itself. Other questions on 1773?
I guess the one thing is, if it comes out that they're not an accessory use, then why would you need the bottomlands? Because if I understand it, that if they're not an accessory use, they can't run the business there.
They can. They have an approved site plan review, which makes it more confusing as to why they're appealing, but that's their right.
Okay.
Yeah, so they came in front of the Planning Commission. The Planning Commission considered them to be similar to a marina operation, and so the Planning Commission reviewed and approved a certain number of boats, certain number of jet skis, with the assumption that they would be operating with this dock permit.
Okay. Thank you.
Matt, did you have something?
Yeah, so specific to that site plan that was approved, last summer? Does what's proposed here, you said, is consistent with that? So the watercraft count, and were there any conditions related to like lot line setbacks or anything?
No, nothing related to lot line setbacks in the
Related to the dock?
Great Lakes.
Okay.
Yeah. There is lot line setback requirement for any buildings, and the shed that they operate with their rentals is, because this is a principal use, is considered a principal building, and so that shed is, cannot be in use under the site plan review as approved by the planning commission. So that to me, I guess, from my perspective and my understanding, that's the main difference in the way that they're operating with the new site plan approval by the planning commission. Is the rental operations take place on the dock without a permanent structure.
Other questions for Claire on this? I know I have a question or two for Sabori.
Oh, I just have one comment.
Sure.
The Eagle is still ultimately going to approve or not approve. We're just saying we saw it and we're
Yeah.
passing a concurrence resolution.
Yes.
But it's still down to Eagle. They're the ones that determine if it can actually happen or not, correct?
That's my understanding, and it's the dock permit that they have. We have to do the conveyance for the area needed for that dock. Mhm. Yep, and this configuration that they're asking for the bottomland conveyance for, this one that like takes it's like an upside down L with that circle in the middle, or on the upper right part, that's what Eagle has permitted. But we do have the choice on whether or not we want to do the bottomland conveyance for it. We have already done the bottomland conveyance as it's shown that it was approved in March of 2021. Thank you, Claire. So, Bori, I did have a couple questions for you.
You bet.
Between looking at what the dock configuration, and I understand that we're looking at the bottomland conveyance, so that area that's needed for the dock, but I am just curious, it looks to me like I don't know, the bigger boat hoists, the larger squares versus the smaller ones, it looks like you've moved more of those out. Could you kind of explain some of the differences in what you were trying to do or accomplish?
Absolutely, yeah, so this was a multi-year process with Eagle. I think we had 3 different public comment and hearing periods, and so there was a lot of feedback, a few hundred emails, a lot of meetings. What we really settled on was, in an effort to have more of a buffer with our neighboring property, we agreed to eliminate the use of the west side of the dock. If you go up and down this stretch of beach on East Bay where all the hotels are there in the Miracle Mile, you'll notice that 9 out of 10 docks are on or immediately adjacent to the property line for all properties, all boat rentals, all hotels, all condos. Pretty much everybody puts their dock immediately on the property line. We're the only dock on East Bay that does not have use of one side of the dock. It was a pretty big concession for us to lose all that broadside dockage up the 300-plus foot long dock. So we had to think on our toes and come up with some alternative layouts that would allow us adequate space to pull in and out of the boat slips without having the use of the west side. And so every change that you see on here in terms of the placement of the boat hoists is pretty much stemming from that one major issue. There are a few other considerations that we did kind of pick up as we went through this process. This was our first dock permit process, and I think it's not just us that is learning through this, but maybe you as well. It's not that common, and we're kind of figuring it out as we go. What we found is virtually all of the dock permits that were issued in East Bay Township did not account for the changing water levels. Strangely, we have experienced the highest high and the lowest low of the last 100 years, both within the last 12 years. So we've had some pretty extreme shifts. And so the reason why you see a slightly different southern boundary is based on where the shoreline was when we had it surveyed. And because of this shifting and changing water level, Eagle decided to issue a permit that was based on the shoreline rather than the ordinary high water mark to give flexibility for the changing levels. Because you'll notice that we placed our southern boundary to the lease area a little bit further north, we also shifted that northern boundary a little bit further as well to accommodate that same shift. And I'm sure you probably noticed just driving by the bay this winter, we've probably gained about 75 feet of beach
Yeah.
since last year.
Yeah, Jen's Park, if you guys want to see it, we just gained a bunch of property. Yeah. Can I ask you, what is that circle to the right?
That circle to the right is a temporary mooring, and they put in a swing radius to accommodate for the length of the chain and rope and everything else for the boat.
Okay, thank you.
And that was placed in there in response to the loss of temporary dockage on the west side. We'd asked Eagle to give us a little bit more flexibility so that we had more places to park boats in between rentals, because we conceded and gave up that west side of the dock.
Okay. Any other questions for TC Water Sports?
Yeah, I guess I've got one. So there's the bottomlands conveyance, and then there's the dock, sort of the dock layout plan. Are both of them related to each other? In other words, could you change the configuration of the dock in the future without any type of permitting?
We would still have to apply for an Eagle permit. The bottomlands conveyance is really acknowledging that outline, the outermost boundary of the lease area.
Okay.
Within that boundary, there can be changes made, but it would require us going back through the dock modification permit process.
Okay.
We just placed it there as a reference so that you guys knew the intent behind what we were looking to do.
Okay. Other questions? Okay. Well, I guess the way I'm looking at this is, I know that there have been issues with the activity and the neighboring property owner. I also know they have an approved site plan. So, you know, the dock configuration, to me, when I saw it, if I were a neighboring property owner, I would want it placed more on the eastern side. So I've found that to be more favorable than what was originally placed there, because all of the activity was happening on that side. And then when you go to swing out to go into the bay, you're going even further west. So I would prefer to see it how it's being requested, where it is on the east side. And then I guess beyond that, as far as the bottomland conveyance, I've never known us not to approve a bottomland conveyance. I mean, this is a East Bay property with looking to have a dock, which is not unusual. So you will notice that the change on the proposed 2023 resolution is pretty much the same. It just changes that wording to approve, which isn't what I understood was being requested last time, but I do understand that that's what's being requested this time.
I guess I've got one other comment, Beth.
Sure.
You know, taking into consideration some of the sensitivity with past issues around this particular issue, you talked about them in length. I guess the square footage, and they define on these permits, the original, the one that's current on file, is just shy of an acre, 0.88 acres. And this new proposed is 1.44 acres. And if I understand what the applicant's saying, that they could potentially revise the dock layout without coming back to the township, because we've already approved the bottomlands conveyance. And in the event that some of the legal activity going on with the ZBA accessory use case gets overturned, there could be a potential that in the future, we've just expanded by almost 50% the square footage of area that's approved for bottomlands conveyance, and would allow them to then expand this dock sort of unilaterally without, you know, any involvement of the township.
Okay. That's a point noted. Are you anticipating changing that dock configuration? Does this dock that you're suggesting meet your needs?
This dock that we're suggesting meets our needs. Keep in mind that if you guys look back at any of these old conveyances from the early to mid-2000s, you'll notice that pretty much every single other conveyance that you issued had a perimeter around the dock in the drawing that was about 5 or 10 feet. So if, let's say you had a T-shaped dock, you'd have a T-shaped bottomlands conveyance that was the exact same shape, just slightly larger. The problem with that is this changing water level issue. If you have a bottomlands area that's only 10 feet larger than the dock, and the dock moves 75 feet, then effectively what that does is it doesn't allow the entire T to fall within the bottomlands conveyance area. And so as a result, not a single dock on East Bay is within the conveyance that you guys have approved. Not one, besides mine. And the only reason why I'm able to do that is by having this more of a rectangular shape, so that any T-section or finger dock that we have could come in all the way up to shore or can go all the way out to the end, and it gives us that flexibility for these extreme changing water levels. That's the only reason why we have such a large lease area, is because we're the only dock that's actually attempting to follow within the guidelines. We have no desire for the dock to be bigger. We're talking about a couple $100,000 structure here. Costs a lot of money to install and remove every year. We want it to be as small as it can possibly be and accommodate the water depths we need to get our boats out. Keep in mind, while the dock permit could be reconfigured to be different, we would still have to apply for a new site plan to adjust for more boats if we wanted more boats. We may not have to come back before you for the dock permit part of it, but as you brought up, Mr. Cook, we would have to come back to you regarding the site plan. So this mirrors what we have in our site plan. That's our intent. We don't desire to be any bigger than what we have here. We're content to have that, but we just need to have some flexibility to move in and out with the water levels. And some of this also, this extending the bottomland lease area to the east slightly, was to accommodate for the swing radiuses that Eagle required us to have. So keep in mind, they've vetted the property line, they've vetted the distance, they've already looked very closely at how much area we need to come and go between the property lines. They've also looked at how much, the average 26-foot boat swings in the wind. And so this was what Eagle came up with us in partnership. This is what they told us we need to do to accommodate what we've asked for previously. And we weren't aware of that when we applied the first time.
Okay, so based on that question and that answer, I have two follow-up. One, Claire, I'm going to steal you back up here again. I saw you back there quickly counting. Is this consistent with the site plan?
Yes. Sorry, just for recording. So the site plan, Planning Commission approved, and correct me if I'm wrong, it's 8 boats and 14 jet skis and 1 emergency?
I believe it was 9 and 12 with 1 emergency.
Okay, so I would need to double check, but the Planning Commission has a specific limit of total number of jet skis and boats, and so there would be no flexibility to go beyond that. That'd be a violation of the approved site plan.
Okay, I bet you could find that really quickly too, couldn't you?
I could, yeah.
Would you do that? And we'll finish, if we need to, we'll go on to the other property real quickly. So Bori, the other question that I had for you is, if that's your intent, this is consistent with the site plan, you're not intending to do anything different, then you wouldn't have any issue with us adding a clause of the resolve that our bottomland conveyance is based on, well, it does say this dock permit, but is specifically only for the dock configuration presented to us.
That's fine. Yeah, I'm fine with that.
Okay, so that is an option to the board. We could do that, and I understand it, we don't know that would necessarily make it to come back, but that would be signaling our intent to Eagle, I believe. So
Put that, just
resolve the East Bay Township Board of Trustees of East Bay Charter Township that, okay, we approve the final configuration submitted, blah, 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 to the Great Lakes Bottom, fully describing the dock permit. I would say number 2, the bottomland conveyance is approved only for the dock configuration presented on 4/5/2023. And in Eagle permit, and then we'd place that in there too.
I have a question or a request if we are going to do that.
Yeah.
Just to clarify, Eagle's intent behind this configuration is that this is the maximum, not the minimum. And so if we opted to delete a section, we could delete that section. If we wanted to put one less boat hoist in, we could put one less boat hoist in.
Yeah.
So that it doesn't have to be the exact configuration, as long as it's the same configuration, less any deletions.
So what the other option we could do is we could scratch that verbiage and we could put this bottom line conveyance is approved on, based on the number of boats and so forth that's in the site plan.
That's fine.
Okay,
Well, I guess it kind of brings me to another question. I mean, we can count the slips, but are there 2 temporary moorings or 1?
There are actually 3 separate temporary moorings. 1 is for boats and 2 are for jet skis.
are they down at the bottom, those lines?
Yeah, those lines
parallel
on the
lines?
bottom. They're basically a drag line that has a temporary clip for a jet ski so that you don't have to hoist them between every rental. And that one to the right on the northeast corner is for a boat.
Oh, the one with the big radius around it?
Yep, it says temporary boat mooring underneath it on the bottom left-hand side.
Kind of in the middle of all
Kind of hard to see. It
measurements.
has a dotted line going through it.
Claire, what did you find out?
Yep, summary was accurate, so it's 12 jet skis, 9 boats, plus 1 jet ski for rescue purposes.
Okay. What's the board's pleasure?
I think we could add, I'm sorry, I'll make a motion, since that's what I should do.
There's 14 hoists for the, so wouldn't that be 12 plus 1 to get to 13 total, Claire? You said 12 jet skis, right?
Yeah, and I think the rescue one, if I'm not mistaken, is moored away, is moored separate from the dock.
No, it's on the same style hoist as the rest of them.
But so that would make 13 total, right?
Yeah.
That are approved, but there's 14 on the dock plan.
And if you want to limit that to 13, then that's fine. That's what we're approved for under our site plan.
Yeah.
Okay.
Okay, Tracy?
Sorry.
It would be, I did write that down, resolution,
2023-15.
So I would make motion to approve Resolution 23-15 with the addition of the second resolve to, I want to say something, the maximum boats to be, or maximum watercraft, because they're not all boats,
okay.
as the 12 jet skis plus the emergency and 9 boats.
So that number 2 would be East Bay Charter Township does hereby approve the configuration and bottom lines conveyance subject to a limitation based on Planning Commission site plan approval of 12 jet skis, 9 boats, and 1 jet ski rescue.
Emergency, yeah. Yes.
Okay. There's a motion. Is there support?
I'll support it.
Motion is made by Bartlett, supported by M. Cortade. Further discussion? Okay, well, it's a resolution, so we'll do a roll call vote.
Bartlett.
Yes.
M. Cortade.
Yes.
Cook.
No.
S. Cortade.
Yes.
Lyle.
No.
Friend.
Yes. Okay, thank you. We'll move on to the next one. Are there anything specific you want to point out in this one, Savori?
Let me pull it up. I've got it on my phone. Give me just one second. I believe the biggest issue on this one was the length from shore, the total distance north to south. Again, to accommodate the changing water levels, but more importantly, from Josh Crane at Eagle, if we're going to have any buoys for navigation, then those need to be incorporated into the lease area. And because we would like to place them out past the end of the dock where they're visible and usable, as the dock changes, we didn't want to have to keep the buoys in the exact same place. If the dock's out past the end of the buoys, then they don't serve their purpose.
So it looks like there's a difference of about, what, 110 roughly?
Correct.
Okay. And the width looks just about the same?
Should be about the same.
Okay. And the configuration looks pretty darn similar too. Little bit of shift in the first one.
Yeah, and that was, the shift in the location of those jet ski lifts towards the south end was based on some questions that Josh Crane at Eagle had about turning radius and some more technical things. We had to have a specific distance from the neighboring property line for navigation and to have an adequate turning lane.
Okay. Do you have what you need there, Glenn?
We're trying to find his page number.
Here, you can take mine here. Glenn, just take those.
Thank you.
Okay, questions on 2155 Munson? Is there anything related, Claire, to planning with this one? As far as any approvals or anything, I mean,
Well, there's been an approved site plan for the conference center.
okay,
And so as a part of the planning commission's approval for the conference center operation, the understanding is that the conference center can use this dock for conference-related activities, but not for other activities that are not related to the conference center.
So it's still private use, people can't.
This is
Right, so one
recreate
example
on
would
land.
be having some sort of like a boat show at the conference center.
Conference center,
okay, gotcha.
that address.
And it's not open for just people off the street to come rent boats in and out?
Right, that was explicitly stated in the site plan approval, that that's not part of the approval. That would be a violation of the site plan.
Okay, all right, thank you. Any questions on 2155?
I just want to be sure. So this has the address for Sugar Beach on it, but it looks like it's the convention center.
What address is up there?
Huh?
Does it say 7?
2155 is Sugar Beach.
No,
No.
155 is the conference center property.
Here, where it says,
The old waterfront.
But-
inn.
That one should
Should
have
have
been
been
21.
Yeah.
What page is that one on? Can you tell? Where's the
This
footer?
is,
Yeah, it got messed, the footer got messed up when we, yeah, that's fine.
yeah, I can't barely read that either.
Okay.
This is.
You
the
can see it
conference
because
center, it's just the wrong end.
the bay's on the left side there, right?
Yeah.
Matt?
yeah,
Yeah.
it's the same picture, just.
Yeah.
That was confusing.
Yep. Okay, are there any questions or is there a motion?
So, I'm sorry, I missed the question about people off the street can't come in and rent.
No, it was explicitly restricted in the,
So Who's
approval.
renting these?
So it's to be used in conjunction with the conference center. So if they had, say, for example, a boat dealership conference there or something like that, they could bring in sample boats and put them there at the property for during the conference.
Okay.
I'm
That's
trying to
the
think of what
only
other
time
type of
you
conference
use
you would
it?
have. What?
There's a little confusion on this one here, because we've entered into an agreement with Josh and Tanya Werfel, who own the Harbor Brook Hall, but we still own the property in the short term. What we're really looking to accomplish is preserving the value of this until the property closes. And we believe in good faith that it will close. We believe in good faith that Harbor Brook Hall will end up owning this property in about a year. But we've spent an extraordinary amount of time and effort and money to get this marina approval. And we're not looking to get this approval specifically based on Harbor Brook Hall's use. We're looking to get this approval based on the original intent, which was as a boat rental.
Okay. That makes sense, because we were kind of wondering internally.
So how does that work, Claire? I'm sorry, how does that work with the approval that the Planning Commission gave for this property? You're looking at me like I don't know what I'm talking about. Sorry to put you on the spot.
So, so I guess what you're asking is if this property was to not change hands and it was retained by TC Water Sports?
Right.
Well, so.
I mean, that's what the approval,
The Planning Commission has approved 2 site plans recently at this site. The first one was for TC Water Sports with this dock layout that you're
Right.
seeing, and it was the older version of the Bottomlands conveyance. So
Right.
they received site plan approval at that time to operate a jet ski boat rental out of there, along with some condo rentals. And so the Planning Commission approved that site plan, and since then has approved a site plan for the conference center. So I guess from planning and zoning perspective, both site plans have been reviewed and approved by the Planning Commission. If for some reason the conference center didn't move forward and they reverted back to the TC Water Sports operation, I would think that they would come back for a site plan approval, and I would anticipate that it would be the same,
Right.
very much the same process and the same Bottomlands conveyance and
So for the
dock.
conference center, did the site plan approval also include a dock like this?
the exact same one, yep.
But it still said no one can use the dock unless they're using the conference
Yep,
center.
the condition of approval was that any activities related to the dock would be in conjunction with the operation of the conference center. And Josh Warfel, the applicant, gave an example of having like a boat show, that interest in
Okay.
having that type of.
But like the
Venue.
wedding party that goes to the conference center can't go out and use the boat? Or they could?
Sounds like they couldn't.
They could use
The
it,
wedding,
The bride
wedding
could
party could
arrive on a
use-
boat.
yeah.
Matt, did you have a question?
No, there will be no permanent boats moored there, because it's not being used that way. They're just for whatever's going on in the conference center.
No.
That's my understanding.
Yep, okay.
Okay.
one
Sorry.
question I
Sure.
have that probably doesn't pertain to the bottom land, but, did they get the parking figured out for the conference center? Because they're talking 300 people and they got 40 parking spots or something.
Right now, they have 47 parking spots, so they have approval to have a maximum capacity of 94 people, because it's 2 people per parking space. Did I do that math correctly? So, they would like to eventually get up to 300 people, and that would require some additional parking
Parking.
agreements, and it would require them to come back before the planning commission.
Thank you.
Okay.
As the property owner, respectfully, we prefer to focus on the TC Water Sports portion of this application, and if Harbor Brook Hall desires to have any change, then I can speak to Josh and Tanya about that, but I would expect that they would be coming before you for a separate conveyance for that use specifically. So if you want to put any restrictions on the guests from off property, then I would ask that we hold off on that until they apply for a separate conveyance.
So even if the property changes hands, it's still TC Water Sports until?
Yeah.
or-
East Bay Development Group is my holding company, but I'm the property owner, so the waterfront property rights
Are
are
his,
mine.
yeah. Right now, they're just leasing,
It's
kind of,
private, personal business, but it
Yeah.
has not transferred yet.
Right.
So
okay.
at that point in time, we could address that issue.
Yep.
Okay, other questions? Is there a motion?
I'll make a motion to approve Resolution 2023-16, resolution to acknowledging the final conveyance of Great Lakes Bottomlands for the address of 2155 US 31 North.
Okay, is there support?
I'll support.
Okay, motion is made by M. Cortate and supported by Bartlett. Further discussion? Roll call vote?
M. Cortate?
Yes.
Bartlett?
Yes.
Lyle?
No.
Cook?
No.
S. Cortate?
Yes.
Friend?
Yes. Okay, thank you very much. Have a good evening.
Appreciate it.
Okay, with that, we will move on to short-term rentals. So we will take public comment at the beginning of this agenda item. With that, I'm going to ask Ann to go over the public comment rules because we didn't at the beginning of the meeting.
Sure. The purpose of the public comment is to give members of the public an opportunity to express their views and opinions to the members of this board. To maintain order and ensure fairness to every speaker, the following rules must be followed during public comment. Speakers will approach the podium and introduce themselves by stating their name and address, and then proceed to make their comment. Each speaker will be limited to 3 minutes and is only allowed to speak once on the same matter. Communication previously emailed to the commission is not necessary to read aloud. Public comment may not be given to another member of the public. Any arrangement for speaking on behalf of others must be arranged prior to the meeting. When your time is at 2 minutes, 30 seconds, you'll be alerted with a yellow signal to wrap up your comment, and at 3 minutes, you'll be alerted with the red signal, and the chair will ask you to conclude your comments.
Okay, just so everyone knows, we've spared no expense with the cardboard cues there. So with that, I imagine there will be considerable public comment. So what I am asking you to do is when someone is speaking here and you know that you want to make public comment, please don't wait in your seat. Come up and stand just behind them, maybe give them 3 to 6 feet or something like that, and just kind of create a queue there so we keep that going so that we can keep the meeting going. And with that, we welcome your comments, and please feel free to step up to the podium and make those comments.
Let's try again.
Absolutely. How are you?
Yeah, I've already told you that.
Okay.
Ken Freimeyer, 914 Mitchell Street. This is in the Pine Grove subdivision. I have a short-term rental that is across from my house and one that is right next to my house. It is my belief in that over the discussions that we've had on short-term rental, it is my belief that these should not have been allowed in the subdivision at all. Back when they started this, they approved it. I didn't know anything about it then, and suddenly it has blossomed. It appears that while that you're showing about 145 or more allowances for short-term rentals in our total, A very high percent of that is in our subdivision of Pine Grove. There, you're looking at about 2% for the number of units that you have, but in our subdivision, that percentage is much higher. It's probably 15% or more in there. That's way too much, and it won't meet any of your requirements in here. They really shouldn't be there. These are homeowners in there. They're occupied homeowners, or they are rented on a long-term base, or a 30-day lease where it just keeps moving on. The short-term rentals, I reviewed some of the recent letters from the people that own short-term rentals, and nearly every single one of them are only interested in the income in there. It's income-based. The homeowners in there are interested in our lifestyles, our quiet enjoyment. And we really don't want to see any of them in there. But you're probably going to have to work around that. And if you do work around it, there is one thing that I have not seen in here. I brought up last time. It behooves you to set a limit on any single short-term rental for a time span. For example, the one across from me, you should set a time limit that it cannot be used as a short-term rental for more than 3 or 5 years. If I'm in my home, I have a family, I don't want different people in there every day of the week. I want neighbors that I can get to know, and that's the way it's been. We've been able to get to know our neighbors. I don't know these people in these short-term rentals. They're anywhere from college kids to families and wedding parties. I don't want to see them. You need to set a limit on these so that they simply can't be turned over to a brother, to their son, to their grandparents, because it's just going to keep on going down the line. The next thing you know, this house has been used as a short-term rental and irritated the neighbors for 30 years. Thank you.
Thank you. Hello, how are you? Could you introduce yourself? And if there's someone else who'd like to make public comment, please get up.
My name is Mike Iruli. I live at 928 Tamarack in the Pine Grove neighborhood. I am in support of any and all regulation on short-term rentals. We are all aware of the problems with STRs, the negative impact on the local housing market, the decrease in school funding as these homes no longer house school-aged children, the loss of neighborhood to a hotel district, among others. I am in support of all restrictions on STRs and actually wish they would go further. But I realize the STRs are never going to go away. The cat is out of the bag, so to speak. The lack of limitations on STRs has allowed investors and corporations to take advantage of the situation. The proposed ordinance change will hopefully limit the amount of STRs in the Pine Grove neighborhood. The proposed ordinance will set a 1,000-foot limit between STRs, but that is only for the new licenses. The 6 STRs that are less than 1,000 feet from my house today are most likely never going to go away. For that reason, I am concerned with the enforcement of noise complaints of STRs. I am grateful that the Township has hired Preston and improved the reporting violations procedure. However, I feel there is much work to still be done. As Preston has acknowledged, the reporting system is not perfect. We have experienced problems, mostly noise issues, with the STR next door to us. We have called the police numerous times, asked for a written report, asked for a ticket number, and follow-up discovery there has never been a report made nor a ticket issued. If you doubt this, please inquire Preston how many comments, reports, or citations have been attached to the 12 times the sheriff has been called at 936 Tamarack Street to address late night, early morning noise complaints in the past 3 years. The answer is 0. The lack of professional follow-through and enforcement of township ordinances by the Sheriff Department only reinforces our distrust in the reporting system. And even if they would happen to be reported, I am concerned there is no repercussion for violations or disturbance issues. The ordinance states the transfer of an STR license will be allowed to a direct family member. I'm concerned, how is this going to play out when a corporation owns the STR, decides to sell the property? I have no doubt they are strategizing and looking for loopholes now to pass the STR license on. The STR license is a privilege, not a right of homeownership. I live in a zoned residential neighborhood, and commercial real estate investors looking to operate hotels have taken advantage of the lack of regulations concerning STRs in East Bay Township and should not be encouraged by allowing any STR license to renew past the year 2025. Short-term rentals fragments the community. Thank you for your time and your work.
Thank you, Mr. Irelli. Hello, how are you?
I'm fine, thank you.
Go ahead and introduce yourself.
My name is Fran Burkett. I live on High Lake Road, and I'm a riparian owner. And there are several short-term rentals on the lake. Most of them are right across from me, where I get to hear everything that goes on over there. Some of it's kind of fun, but, you know. But one of the concerns that I have about short-term rentals is that too many in an area, and I think you are beginning to address the restrictions necessary for that, is that it can destroy the neighborhood. I think that's kind of what you were saying. You know, you don't know these people, and on High Lake, we get to know each other by walking around the lake and going to the pancake breakfast and paddling around the lake and saying, hi, how are you? That doesn't happen when the people change every week over there. The other concern I have is that there are there, maybe I should make this a question, are there short-term rentals that are functioning without permits? And how do you find those? And how do you enforce these? And what are the rules against that? And so that is a concern of mine too. So my concern is to preserve the neighborhood, to restrict the number of rentals, and to make sure that we preserve our neighborhoods here in East Bay Township. Thank you.
Thank you. Next, please. And whoever would like to go next.
Good evening, how are you? Stacy Slater, 854 Pine Grove Avenue. Thank you again to the commissioners for your continued effort in the short-term rental discussion. To reiterate what everyone else has been saying here, obviously, the loss of our neighborhoods is weighing heavy on us. We've talked before about the the motels masquerading as single-family homes in our neighborhoods, the loss of seeing our neighbors walking around, knowing who's there. I appreciate the discussion of the percentage of housing stock, but again, like it was just mentioned, inordinately large density is in Pine Grove and of course in the Lakes area. Just a bad idea. Appreciate the buffer, again. There's work to be done there. Same thing with the parking and talking about the boats, but I am concerned about there's no discussion of the number of parking spots. We are seeing, it is a parking lot. I have a short-term rental across the street from me. Somebody else mentioned this just recently. We're not seeing people coming up here and being one with nature in Traverse City like we used to. You know, remember? We all got along. We loved having the tourists come up. We showed off our town. We were so happy. And this has nothing to do with the legacy renters, right? These are the ones that are hiding behind the legacy renters, okay? So, bachelorette parties, I've got, you've heard me before. We've got the minibuses pulling up with the brew pub tours. A truck pulled up with a trailer that unloaded a little mini bar that came out on wheels. I mean, it's not a neighborhood. I appreciate the discussion regarding the septic period. That's super important. My concern is, how will this be monitored and enforced? And is this on their honor? Appreciate, again, the discussion regarding the licensure transfer. Unregulated license transfer threatens the value of our homes. Not sure how that works. If a short-term owner's license has lapsed, I had to chuckle when I was reading some of the information from, apparently I missed all the fun in February. So, oh, I let it lapse. Oh, I didn't know. How does that work? You're a business owner or you're not a business owner? What's it going to be here? So they let their businesses, if it lapsed, it lapsed. You lose it. Concerned about their livelihood? Well, if I make a poor investment, the township is not going to pay for my poor investment. So if a short-term rental owner has all his beans wrapped up in a short-term rental, oh well. My livelihood is at stake as well. I've told you guys before, thank you again for listening to me. We don't go outside. We're trapped in our home. There's no enjoyment there. There is no peace.
Could you wrap up, please?
Yes, thank you.
Thank you.
Other than that, again, I appreciate you all, and thank you for not being bullied by threat of legal action and thinking through this. And since the genie is already out of the bottle, let's do another extension on the moratorium. Thank you.
Thank you. And did you, I'm sorry, I must have missed it. Did you introduce yourself with your name?
Stacy Slater, 854 Pine Grove.
Sorry, I was making a note and missed it. Hello, how are you?
I'm fine. Susan Hem at 918 Juniper Street. I have 3 short-term rentals I can see from my front yard, one next door, one across the street, and one on the other side of the alley. I'm not totally against short-term rentals. I just don't like seeing so many clustered together. There's just 2 blocks down the street, there are 4 of them right by each other, and I know another location, there's 2 of them right next door to each other. I don't like the idea of license being passed down to family members. Maybe the one who has it now will be a good person and owns it and is really good about who they rent. Who knows what their sibling or sister or child would do, and they might just rent to anybody. Also, an owner should know when their license is due. And I don't see why they should have such a long term they can renew their license. Most places you have like a 10-day business day, you got to have it renewed, and that should be what it is. You know when your license is due, you pay when your license is due, and don't expect 30 days, 60 days down the road to be able to do it. I like the 1,000 feet distance. That will spread them out more. Also, parking can be a problem. The one that says 4 of them right near each other. It's a small place. I think it's maybe 2, 3 bedrooms, and there's usually 4 cars parked out there in that particular one. And they're mostly parked on the alley, and the alley's getting beaten up because of the traffic going on at all times. Well, thank you.
Thank you. Next, if there's somebody else, because if there's nobody there, I'm going to end it pretty quickly.
Good evening, my name is Sue Torgerson at 4440 North Spider Lake Road. 3 points. One, I'd like to reiterate the message in the attorney's letter about the indirect effect of not just the short-term rental owners and the impact on income, but those that support them, or that they support, who are also part of the community and that are relying upon that income to support their families and their own personal goals. What I didn't see called out was that these people that are coming in the shoulder periods, which is when we don't, in May and June, you don't necessarily expect everybody to be there, but the businesses that this community supports are looking for that business. So all the restaurants, the tours, TC Water Sports, if you take that second period away during those periods, that makes those businesses much more vulnerable. That at a time where we're trying to expand tourism to support sports activities and concerts, in off seasons, we're actually taking away a period of income for everyone involved, and actually just time for people to enjoy the period up north in Michigan. What I also didn't see in the correspondence was the support of trusts. Trusts have been a traditional part of how assets may be held and passed down from family members. The LLCs are a large part of what we're talking about today, but the trust is still a viable option to protect and pass your assets along. So I think that the rules need to address that. in terms of how that is, how the property may be continued through the trust, because it is a family affair for most people up here. And then third, with regard to the grandfather clauses, that if any existing licenses are grandfathered in, is it based upon the rules and regulation as the last, before these new regulations? So I think the distance period is probably one of the biggest concerns that I'm hearing a lot across the board. But also the septic might be, I mean, obviously fully willing and support our septic system on an ongoing basis. But I just was looking for clarification on that. I wasn't really certain. So that was it. Thank you.
Thank you. How are you tonight?
Good, thank you. My name is Tony Stainfield. I live on 2580 Twin Bay Drive, here, Traverse City, on East Bay. And I'm here as a member of the SALT organization, which is Spiritual Activists Leading Together, and I'm part of the housing committee in that organization. We are concerned about lack of housing, low-income housing, and also homeless population. Traverse City does not have housing for people who work here, does not have housing for people who are sick. And I think a gentleman here said that there is a big difference between residential and commercial. So yes, people can make money. So let them open a hotel, a motel. But residential, I think that we all have the rights to quiet neighborhood, to know our neighbors, and also to provide housing for our people, for our local people. So I recommend that you extend the moratorium and try to decrease the numbers of short-term rentals so that people who really need housing can afford to be here. Thank you.
Thank you. Next. How are you?
I'm well. How are you?
Good.
My name is Leanne Lindsay. 3 years ago, my daughter and son-in-law bought a overgrown, run-down dump of a house on Indian Trail and turned it into one of the cutest houses on the street, thereby enhancing the property values of my neighbors, who, by the way, are our friends. When there's something happening at the property, like, oh, big tree fell, they come and help us move it. When we're there with our grandkids, painting the property or enhancing the landscape. Also nice to see kids in the neighborhood. They come over and bring cookies. Our neighbors are our friends. We don't live there. It is a short-term rental house, but all the people that we rent to have been very respectful. We tell them about the noise ordinances. We tell them when there's a high fire hazard. They don't have fires. They're very respectful to our property. And there's 3 months out of the whole year that we're able to rent it every day, back-to-back rentals, June, July, and August. After that, it's over. We have 3 months to make enough money to cover our expenses for the rest of the year. Not letting us do that for the entire time, limiting the amount of days that we can rent it per week is unreasonable and unbased. There's no reason for it. We've had no complaints from our neighbors or anyone about our short-term rental house. It's the cutest house in the street. Go check it out. Our neighbors coming by, how are you doing? Let's see what you've done so far. Love what you've done with the place. There's been no complaints, and it's the nicest house on the street. I wish you would consider letting us rent further, not just limiting 4 nights per week. That's unreasonable, and there's no basis for it. So that's my opinion. Thank you very much.
Thank you. Next. Hi, how are you?
My name is Kathy Kowaleski. I live at 928 Tamarack in the Pine Grove neighborhood. I'm fully in support of any and all regulations that will decrease and regulate the short-term rentals in East Bay Township. The previous lack of regulation, density limits, occupation stay limits, enforcement of violations have resulted in the Pine Grove neighborhood becoming a hotel district. I bought my house 23 years ago in a quiet residential neighborhood, zoned as a single-family residence neighborhood. I did not anticipate living next door to a hotel with its constant stream of vacationers, cleaning crews, cars, and noise. I did not anticipate that I would live within 1,000 feet of 6 other short-term rentals. Previous to being a short-term rental, the house next door had been a home. Previous to being a short-term rental, the house next door had been a long-term rental. housing people that worked in the area, sent their kids to school in the area schools. It was then purchased by a family with young children. When they sold the house, it was bought by a corporation that owns 6 other STRs in the area. This house now is no longer available to the long-term rental market. The students at NMC, the workers at the local businesses, the Coast Guard employees, it is no longer available to a young family, a first-time homeowner, a retired couple looking to downsize. Every one of us knows someone who is looking for housing and is aware of all the difficulties involved. The proliferation of STRs only exacerbates the local housing problem. Personal property rights are often brought up as an argument in favor of STRs. The majority of STRs in our neighborhood are owned by investors, not a person. These corporations and investors are not living in these homes. They never have and they never will. They are taking advantage of the township's lack of oversight and regulation to make money. It is the homeowners who bought in this neighborhood who are now having their personal property rights violated. We bought in a zoned residential neighborhood, and we now live in a business district. I have yet to meet anybody that said, I wish I lived next door to a short-term rental.
Thank you. Okay. Hello, Carol. How are you? Good.
Good evening. Carol Kusel, East Bay Township resident. It's obvious that you and your staff have given considerable time in researching and discerning this topic of STRs. Thank you. Thank you for considering the needs of the short-term rental owners, their neighbors, and our community as a whole, including the environment that brings and keeps so many of us here in our township. 3 topics I'd like you to further discern. 1, thanks for setting occupancy limits based in part on the septic system capacity and for setting regulations on septic system checks and then pumping as needed. A few years ago, experts on this topic attended or spoke at a septic summit, in Traverse City, and they reported that testing shows that not only normally functioning septic systems, but also the improperly functioning septic systems leak into our water systems, including into the aquifers that we get our drinking water from. That's quite concerning to everyone. Also, those improperly functioning septic systems leak into the lakes, which cause alga blooms in the lakes, and then that decreases the ability to use the water and also affects our property values. So please consider including periodic drainage field checks in the ordinance, along with the other things you currently have added. Topic 2, thanks for adding a requirement for all renters to follow state laws to avoid the spread of aquatic invasive species. Consider requiring STR owners to post a link to the state rules in their ads and rental agreements, and ask them to post this rack card from Eagle and the DNR in their rental properties. The cards are free for the asking and could be available in the lobby of this building along with similar materials that are already there, or you could post this on your website so it's easily available for the short-term rental owners. And third, and most importantly, is thanks for setting a cap and a separation distance. Please find additional ways to decrease the density of STRs in the denser neighborhoods, especially Spider Lake, the Lakes area, Pine Grove area, any others that are high density. Consider applying a cap limit on zoning districts. In August of '22, Spider Lake had 36.5% of all the STRs in our township. In March of this year, the Lakes area had nearly 43% of all the STRs. Certain neighborhoods are now clearly carrying the brunt of the STR cap load for the entire township. That's not fair to all the homeowners in those neighborhoods. And those numbers will change if you add those 23 to 30 STRs that didn't renew on time. Also, and almost in closing here, note that cabin courts add another 40 rental cabins on Spider Lake, but those aren't included in the cap. So please, in your finding of facts, ask for an updated map that include all the current licensed STRs, the potential 30 STRs, and the cabin courts. Lastly, consider using cabin courts, bed and breakfast, condos, and any other short-stay rental properties in the separation distance calculations when allocating new licenses. Once again, Thank you for your extended discussion on this. Really, really do appreciate it. Please discuss these suggestions tonight in your deliberations.
Thank you, Carol. Next.
Greg Colezza on Spider Lake. Thank you for your efforts to optimize short-term rentals for the benefits of all the involved parties. We all recognize what important issues, which can be emotional and possibly contentious issues are involved with these decisions. No one really has any issues with those renters who are civil, courteous, quiet, respectful of the property, the environment, the residents, and the neighborhoods, as the vast majority likely are. The problems arise when those visitors are loud, disruptive, vulgar, and disrespectful, and negatively impact the residents in the neighborhoods and their enjoyment of their properties. Please don't dilute it to think that really this isn't a problem, even though only minimal reports of problems have been received by the township. There's probably a lack of active complaints because of a number of different factors. My family have certainly experienced them personally, and we hear consistently from neighbors residing near short-term rentals, cabin courts, as well as resorts. Perhaps the sheriff is called rather than the township officials with the complaints. Perhaps affected neighbors have anxiously tried to deal with the problems themselves. Perhaps the current polarized, contentious society that we have makes some of us fearful of confrontation, so we just put up with these disruptions in our neighborhoods and our quiet lifestyles. My wife and I have resorted to closing windows, noise-canceling headphones, and wearing earplugs at night to have restful time, especially when the neighbors are less than courteous at the short-term rentals. Unlike East Bay Township residents, these visitors pay no taxes to support services or the infrastructure, and they bear no expenses for maintenance of the neighborhoods, lake quality, environmental ecosystems impacted by the increased use and risks such as introduction of invasive species and the mitigation of those invasive species on our waterways and in our environments. Now, there are townships and communities in our state as well as our country, and especially in resort areas, that have moved to totally ban short-term rentals in protection of neighborhoods, except in areas with severe restrictions or in commercial areas, and that's a consideration. How many East Bay Township residents would actually vote yes to allow short-term rentals next door to them or several of them within their immediate vicinity? How many of the present committee here would actually vote yes to allow them right next door? I would be happy to host at no charge any of the township officials here in my extra bedroom during a busy summer weekend when I have an especially problem renter who is keeping us up and causing disruptions. And I say that sincerely, to let anybody here experience that firsthand, to see how disruptive it is to your lifestyle. I've been told that the township, unlike cities and downtown development authorities, cannot levy taxes or charge additional fees for the short-term rental enjoyment of our communities. Perhaps the township needs to figure out some way to defray the township's cost, as well as to compensate the affected individuals, residents, neighborhoods, and lakes areas that are impacted by these short-term rental decisions.
Greg,
please give careful
wrap up?
consideration to restricting the number and impact of short-term rentals in East Bay Township to preserve the character of our neighborhoods and the lakes area. Thank you very much.
Thank you. Next.
Ray Drager at 967 South Hobbs Highway in Spider Lake. And I have 2 short-term rentals. And I have walked in Pine Grove, and I plotted every single short-term rental in East Bay based on the data that was provided by Claire. And it is very clear that Pine Grove has an issue. There is no doubt. I talked to a few people there. There was one guy who had a short-term rental on his right, his left, and directly behind him too. That's an issue, but not every place is like that, like Pine Grove. Personally, what I would do with Pine Grove is get rid of all the short-term rentals in Pine Grove and grandfather in who's there and just let them attrit naturally over a 10-year period. I'm sure there would be zero in Pine Grove, and maybe that applies to some other areas. I think that would work. But there are other areas that have been doing this, that are legacies, that have been doing this for, 80 to 100 years. And that is Spider Lake area, and I'm sure we can come up with a reasonable way to do that. The only real issue I have with the short-term rental ordinance is a 7-day restriction. It really imposes upon the short-term rental because it doesn't work well with any of the platforms that are out there. We're projected out for almost a year with 4 or 5 days, 6 rental days. And if we impose that, then Airbnb will knock every single one of these people every time they cancel $1,000, $1,000. I'm talking about the hosts. So it's quite substantial what would happen. So if we are going to do a 7-day restriction, please do it in a year's time. That way, it gives everyone here that's a short-term rental person and their neighbors that are not an opportunity to make that transition. Instead of, by imposing that upon them, you're really forcing them into a legal battle. And we all know this has taken a long time, 3 or 4 years of working this through. I spent 24 years in the military. Every day, I swear to God, I was in Iraq and in Afghanistan 3 times. All I could think about was coming back to Spider Lake, looking at the peace, the quiet, the tranquility of that place, making my little piece of the pie, never having to have another boss again in my life, just have 2 rentals and live a quiet life. And that's what I want to do. That's what I want to continue to do. I'm a quarter mile from my rentals. I check every single person in, I check them out. I make sure that every one of my neighbors knows who I am, and that if there's an issue, they call me. They do call me too. It's like, Ray, hey man, we got somebody over there screaming foul language, boom, I'm over there. I don't put up with that. So anyways, that's really all I had to say. Thank you. I think you guys are doing a great job. Appreciate it.
Thank you. Next.
Hello, everyone. My name is Kenny Liu, 2527 3 Mile North. We have been running our short-term rentals for almost 5 years. Most of the time, my wife is responsible for the maintenance of the property, while I offer helps as needed. We view this as our family business, and our listing is called TC Memory on Airbnb. And you can visit that and browse the reviews there if you like. We strive to provide the best hosting staying experience in Traverse City to our guests. With that mindset, we have been earned and kept the Superhouse rating since our first year. Our average reviews have been nearly 4.9 year by year, year after year. Our rental property has been the important source of our income of our family. As I'm the full-time engineer, and we are currently raising 3 kids here in Traverse City. Like every middle-class family in the States, the additional income helps our family stay in the financial stable status, especially when the inflation has become very relevant after the pandemic. We could not imagine what our financial status would look like if we did not have this rental property. We have hosted more than 200 groups, or even more than 1,000 guests since we have been open. If my memories serve me correctly, we have only received 1 complaint from residents. When we heard of this, we took action immediately and requested our guests to be considerate of our neighbors. Our guests follow the house rules and respect our house and the neighborhood. Another reason we haven't had many complaints might be that we chose who can stay in the property carefully and are not concerned about leaving the house vacant. We have learned from some bad hosting experience. We decline booking requests of those who do not have any reviews or otherwise poor reviews from the other hosts. It turns out that most of our guests are families, or sometimes spectators and athletes for the sports event. Our property is perfect for families traveling in a group because otherwise they would have to rent out multiple hotel rooms and be spared the experience at home. What I like to express is that the quality of the guests and outcome of the hosting can be somewhat managed. As a host, you can write your own rules at the booking page, and your guests must agree before booking. You may request silence time for the courtesy of the others after particular hours at night, or even limit the numbers of cars to be parked in the vans, if that would be an issue for your neighborhood. What we are not willing to adapt is to, if booking restriction were to be put in place, such as hosting one group per week, that would severely impact the finance of the host and still not solve the concern. As I shared earlier, we have hosted more than 200 groups, and many of them are same-day check-in and check-out. And we have received just one complaint so far. So you are able to conclude that this is not about the frequency of bookings. I would agree if a complaint was reported and if it's later confirmed, definite after investigation, the host should get a warning. And just to some degree, that particular host enters a probational period or even being suspended.
Sir, could you wrap up, please?
Oh, sure.
Thank you.
That's my last few. Imposing booking restriction would penalize a good host like us unfairly, and in the end, good hosts may choose to close down their rentals or living in more beneficial than staying and needing to deal with the regulations that are unfair. Meanwhile, losing rental properties would negatively affect local business because of the loss of the tourists that the rental brings. In the end, the visitors, the township, and the hosts are all lose.
Thank you,
Thank you
sir.
for your attention. Yep.
Next. Oh. Yeah, we're not going to entertain clapping, so that's okay.
Good evening. My name is Ralph Bednars. I reside in East Bay Township on Rennie Lake, and I'm the current president of the Rennie Lake Association. Thank you for all the time and work you have done over the last several months to create a short-term rental STR ordinance for our township. I agree with and support the comments from the Lakes area, the LA community, regarding the concern of an excessive STR density burden in the LA zoning district. Another concern that has not been addressed in the proposed ordinance is allowing non-riparian watercraft access to the LA lakes via STR properties. This increases the threat of aquatic invasive species, AIS, as well as the potential of undesirable watercraft on the LA district lakes, especially lakes without public watercraft access facilities. Public watercraft is the main vector for the transport of AIS in Michigan's inland lakes. Public watercraft should not be allowed access via STR property. Renters should only be allowed safe use of STR-owned watercraft and only on the lake that the STR is located. If public watercraft access is allowed via STR property, a township-administered watercraft inspection and AIS-free certification program should be established. Additionally, you may want to consider requiring STR owners to post a surety bond for the cost of AIS eradication should AIS infestation occur via the STR property. Thank you for your time and consideration of these concerns regarding the STRs in the LA district.
Thank you. Next.
And I'll submit my comments for the record to the recording secretary.
Thank you.
Hi.
Hello.
My name is Jake Mikowski. My family and I live in East Bay Township on Napoleon Way, just a few miles from here. And my family is a short-term rental owner. We own our short-term rental in an LLC, so while it's easy to classify all LLC-owned short-term rentals as investors and corporations, we live here and we have a family here, and our family has lived here for many generations. So some of us are local and care just as much about the community as everyone else who lives here. Listening tonight, it seemed to me that most of the complaints about short-term rentals have to do with either the existing short-term rental ordinance or other ordinances in the township not being enforced. So from my perspective, I would say that a lack of enforcement of an existing ordinance isn't a reason to expand ordinances or create new ones when we can enforce the ones that we already have. I would also just like to say that I heard from both owners of short-term rentals and people who are against them that it seems to me that the problems are isolated in particular neighborhoods or in particular managers of short-term rentals, and that it seems to me a blanket approach to either allowing them or banning them is not appropriate. And so some of the things like the 2.5% of housing stock or the 1,000-foot rule seem to be kind of arbitrary and applied across the board, where it seems more research needs to be done, and that some of these remedies to the complaints that people have could be more tailored to the specific problems. So those are my general comments. I do have some specific comments on the ordinance revisions themselves. First, in Section 3, the occupant definition states that an individual present in a dwelling is going to be presumed to be an occupant unless circumstances clearly indicate that they're a visitor. By definition, a visitor, though, is someone who's not going to stay the night and isn't there before 8 a.m. Or after 11 p.m., so it seems to me more appropriate that you would not presume that someone's an occupant unless they're there before 8 or after 11 p.m. In Section 5F1, the term housing unit is not defined. A justification for the 2.5% cap is not given. And I don't think the township should limit the number of licenses to a 2.5% cap without explaining where that number comes from or what the denominator of that percentage calculation is. So I would recommend that that calculation be made transparent and that you use definitions that already exist, like the one provided by the U.S. Census Bureau. In Section 6B, we talk about the limit moving up to one stay in a 7-night span. I think almost all the STR owners have shared that that's going to significantly cut down on income and reduce many families' abilities to keep their short-term rentals. It also even more greatly impacts those cleaners that we employ. A lot of the cleaners for these STRs are young, local entrepreneurs with their own businesses, and a lot of them are going to be forced to go out of business or lay off staff in order to comply with only one stay in every 7-night period. In Section 6P, I don't believe that the township has provided any rationale for why the radius would be increased to a 1,000-foot radius. Going from a 500-foot radius to a 1,000-foot radius actually quadruples the amount of area that becomes ineligible for a short-term rental. It seems to me that even in a neighborhood like Pine Grove, where most of the lots are 50-foot wide and 165 feet deep, and one person shared that they have 15% short-term rentals, which I'm not arguing is appropriate. However, a 1,000-foot radius would reduce your density to about 0.5% of the housing stock in that area. And you could cover the entire Pine Grove area with just 3 short-term rentals, which is well below the stated target for density. So it seems to me that it's a little bit random in terms of the rules being applied to different neighborhoods.
Could you wrap up, please?
And the last one is regarding transferability. First, the licenses held by STRs being made to identify one person. If you have a family that go in together and they have an LLC and they own an STR, they have to identify one person to hold that license, and only that person can leave that license and transfer it to their children. So it unfairly puts families in a position where they have to pick one person who has an extra benefit over the other people in that LLC. I would also argue that having a home owned by a single family and then transferred down is going to cause less problems with neighbors than by licenses being ended and then just granted to new people that don't have a proven track record of being able to manage their house.
Thank you. Next.
Good evening, everyone. I'm sorry, I have a frog living in my throat tonight, so just bear with the squeakies. My name is John Jury. I live at 1615 East River Road. I am a full-time resident of East Bay Township, and I own an STR at the same address. I have just several questions to ask the board this evening. I don't expect answers back, obviously, but these are things that I'd really like you guys to ask yourselves when you make the determination to vote on the ordinance revisions. One, what does the township hope to accomplish by implementing the 1 in 7 rule, being the one rental in 7 days? Does the township have supporting data that shows that the 1 in 7 rule will remedy the minimal amount of complaints from STRs breaking the ordinance rules as they are written today with the 4-day rule? Does the township recognize the impact on the STR owners and their ancillary vendors by implementing this rule and effectively removing 50% of revenue that is spent within this community? Does the township now have a plan and the infrastructure in place to enforce the revisions? And if not, will you document a plan in the future? What does host compliance really do for the township? Why does host compliance not respond to issues when STR owners are attempting to renew and the system continuously crashes? I personally had to prove that I attempted to renew by showing screenshots, IPs, DNS information, and directly to Leslie before the moratorium that I was intending to renew. Without that proof, she would not have let me renew. Many hosts had the same scenario and were completely disenfranchised and unable to renew. Do you guys intend to make them whole again? Why, because of a few bad apples, are you making sweeping changes to an ordinance that we all worked on so hard in 2018 and 2019 that affects the good players and not enforce the consequences with the known bad apples? We understand that there are definitely issues in the high-density neighborhoods with noise, traffic, violations, occupancy, etc. However, in the existing ordinance, there are remedies to act upon with that individual license holder, not to mention noise ordinances already in place, traffic laws in place, etc. Why is the township determined to effectively punish the license holders who have had no complaints and follow the rules? Why do all the stakeholders in this situation not have a chance to assist in and review the ordinance? We have asked multiple times to sit with the board or have the board create an advisory committee to review the ordinance, document what works, what doesn't work, and make adjustments based off of the recommendations and data that that committee can gather. Yet, we still ask, and it still falls on deaf ears. Have any of you vacationed and stayed in an STR? And if so, why did you choose an STR over a hotel, a resort, or other accommodations? How was that experience staying at the STR?
Can I have your wrap up, sir?
Yes. Last one. The board and other residents of East Bay have expressed concerns about large companies buying up homes and turning them into STRs. In this lengthy process, has any corporate entity presented themselves to the board in regards to the ordinance or the changes that are to be made? You will find that STRs are held in LLCs for the protection of the corporate veil, not to be a huge corporate shark. Thank you.
Thank you. Next. Hello, how are you?
Good, how are you?
Good.
My name is Megan Pollard. I live at 9534 Amadon Drive. I actually own my own cleaning business, and this ordinance would, there's a lot of cleanings I do in within East Bay Township, and a lot of times there's 2 cleanings or turns per week for a lot of rentals. And this change would actually cut my business by 50%, and I'd be forced to lay off some of my employees who use, you know, I mean, that's how they provide for their families. And so I just wanted to let you know from a business standpoint how this would affect my cleaning business. Thank you.
Thank you. Next.
Good evening, my name is Gail Miller, 774 Lake George Trail. I'm one of a handful of hosts who was late to renew my license because I did not get any sort of renewal link from host compliance, and then I lost my license due to the moratorium. I had no intention of being a scofflaw. That's why I got licensed in the first place. But we received no notice that our renewal was late until the cease and desist order was sent more than a year after our license expired. It seems only fair that hosts who fail to renew on time receive some kind of notice within a time frame that allows us to rectify the situation. I want to renew my license and stay compliant. Charge me a late fee if you must, but please allow me to reactivate my license. And please create policies and procedures for late renewals to prevent this from happening to others. Regarding the 7-day booking restriction, our average booking length is 5.9 nights. 44% of our bookings are for 5 nights, 25% are for 6 nights, so 69% of our bookings are for less than 7 nights. Prohibiting us from booking more than once every 7 days will hurt us, yet we've done nothing wrong. The 7-day booking restriction is particularly frustrating since you haven't even started to talk about actions that might actually solve the problem of unruly guests, and unruly guests is the problem. There's been no discussion of increased outreach to residents so they know how and when to submit a complaint. No discussion about how to streamline the complaint process, making it more efficient and effective. No discussion on how to work more cooperatively with the Sheriff's Department to handle the occasional complaint. You have not proposed stronger penalties for hosts who allow parties or obnoxious guests. You have not proposed hiring a dedicated enforcement officer to be on call to handle complaints in the evening. There's also been no discussion about stronger rules for our listings that could prevent unruly guests in the first place. And I'm talking about our advertisement listings on VRBO and Airbnb. You could require that our listings specifically say no parties. Ours does. You could require us to explain that our neighbors are not on vacation and that respectful behavior is essential. Require that we make it clear in our listing that violating a good neighbor rules could cause us to lose our license and for the guests to be told to leave. You could require that we specifically state that our party prohibits party buses. You could require that we prohibit bachelor-type party groups. We do. We would not want these kind of operations or groups in our family cottage. All of these actions have a far greater chance of preventing bad behavior than an arbitrary 7-day rule which will only inflict financial damage but not solve the problem. And you can actually enforce these rules by simply looking at our listings. If you are going to let us operate, let us operate. Lay down strong rules that will solve behavior problems. Then enforce those rules. Shut down bad operators. But don't hurt every host in the township for the sins of a very few. If your goal is to drive us out of business, the proposed ordinance will succeed. If you really want to solve the problem of unruly guests, this ordinance will fail. We welcome the opportunity to work with you to find solutions that work for everybody. Thank you.
Thank you. Next, please.
James Gag, 489 Peninsula Trail. Just, probably going to touch on a couple things that people have already touched on. Just because something is in an LLC, a limited liability corporation, doesn't make it a huge corporation. My rental property is in an LLC. It's my wife and I, and we have operated successfully for years with a 5-star rating and 0 complaints. So, a big catchphrase currently all over the news is we have to do something, But let's think about solutions. When people come up and say, they support anything that hurts people that are running STRs because I've got a bad one across the street from me, I don't think that's a solution. That's a brake job when you need tires. And limiting, the amount of renters in a week for someone that has 0 complaints over several period of time, what's the difference if you have 2 groups of courteous people in a home in a week versus 1? It just doesn't make any sense. And as other people have stated, you're just not going to have weeklies except for a certain short period of time. So basically, I'm just saying solutions, people are talking also about the environmental impact. And somebody mentioned something about, making people that own STR pay into some type of fund that's going to, punish them for, bringing whatever invasive species. My property's on Spider Lake and has a public boat launch, and local people go from lake to stream and there's no boat wash on that lake. So there's just as high a risk, if not more, for just simply having a public boat launch on that lake. And only a small percentage of my renters ever rent a boat, and typically it's off the lake. So I'm just asking for common sense, and don't punish people that aren't doing anything wrong. I would go for what other people have said, and that why are we not, when somebody complains to the township, provides documentation that they called the cops, why isn't there a demerit system against their particular permit? 2 or 3 times, you're revoked. You know, the good people would support that. We just don't support having somebody. Another thing for the people that, you know, had mentioned the cost of these properties and the fact that we're not supporting the school system. We're paying non-homesteaded tax, and you probably don't know about that, but it's quite expensive. And also talking about other different things in the way that it affects the community that I think are just kind of erroneous. I understand. I live next to a long-term rental for 10 years with some very serious problems, including harassment, the invasion of my personal home. So if you think your problems are going to go away by eliminating short-term rentals, or somehow you're going to bring down home values by eliminating and get, you know, low-income housing, you know, in some place where there's a short-term rental, I don't think so, you know. Yeah, they may have driven the prices of homes up, but are they going to come down? If you eliminate short-term rentals, are those homes going to come down to whatever quote-unquote affordable is for families? Probably not. So thank you for listening.
Thank you. Next.
Hello, my name is Jody Ortega, and my husband and I reside at 1549 East River. We are also full-time residents and have been for 19 years in East Bay Township. I have been listening to the public comment tonight from my neighbors of East Bay Township that are opposed to short-term rentals. It is very disappointing to hear how certain short-term rentals are creating conflict for you and your families to live in your home comfortably. Yet I also, as I listen, there seems to be more of an area of concern that I feel that this would be fixable with policies in place that would simply address the specific rentals that are the concern. I would like to make our fellow neighbors aware that every guest, every stay, every time, we are making local recommendations, small business, restaurants, where to get local meat, roadside farm stands, museums, grocery stores, wineries, parks. I could fill a whole page of suggestions that we have given our guests, and without a doubt, the guests that have stayed at our cabin or other short-term rentals have increased our local economy. It is no secret that we live in a beautiful area that people come to visit, and this greatly impacts the community in a monetary way. Other people that would be impacted by this 7-day minimum are that of a young couple that cleans the cabin for us. They closely budget their finances. They work full-time. The husband was full-time in school, recently graduated, and they are saving money for a home. This change would reduce their income by 50% or more. This is not just taking livelihood from our family and other families that own short-term rentals. It is stealing an opportunity from that 40-year-old man that has never started his own fire. The mom who lost her son that needed a place that was safe with solitude. And lost, I mean he had passed away. The parents that struggle to get kids off social media and take nature in, the couples from downstate that want to have a small piece of what we get to experience every day. The cabin with the current arrangement pays for itself, and that's about it. We take pride in our investment and are thankful for it every single day. We can enjoy and share this with others along the road. It can fill our cup all the way up, and we hear the stories that families share with us. In fact, we have a guest book that's 2 inches thick that they will have these memories for a lifetime. I am hopeful that as the discussion continues, is looked at individually with support from our local law enforcement and in place specific policies that do address noise and safety for my neighbors, but not punishing those of us that are wanting to work together.
Thank you. Next. Nope, this is staff. This is zoning administrator.
Thank you. Mark Clark. I work in Traverse City at 810 Cottage View. I had the privilege of coming before the board in February. I'm an attorney representing short-term rental owners. At that time, I think I had 18, and I think we're up to 28. I don't represent any of those big corporations that you heard about. The folks that I'm dealing with are mostly trying to preserve their family cottages. They have 1 or 2 short-term rentals, and they're simply trying to either get through their retirement or supplement their income by being their own business owners, if you will. You know, I have heard the comments. I do feel empathy for those folks that are in neighborhoods where the densities are probably too high for what we have. But what I'd like to do is focus on a singular issue that seems to be most important to the folks that I'm representing, and that is the booking restrictions in Section 6B of the ordinance that would limit the reservations to no more than one rental per week. Under the existing ordinance, the board established a 4-night turnover limitation. Your proposed amendment is perhaps the most significant provision impacting the short-term rental owners financially. Some of them that have told me that based upon their reservation schedules from last year, that this could result in up to a 40% income reduction in their investment. So it's important, it's significant, and it's probably the single most financially impactful provision that the board is considering changing from where they're presently at. And it provides a significant incentive for those folks to consider, a challenge to the ordinance. So, the loss of income opportunity going forward is significant. It will result in the loss of tens of thousands of dollars to some. Those who have already booked a year out that have to cancel reservations will incur significant penalties from the Airbnb booking platform and others. And so it is an important issue, and the record that I reviewed on this single issue does not indicate what the change is designed to achieve, though it certainly will result in less opportunity to rent for owners and certainly far fewer new faces visiting the township and patronizing local businesses. I know you've heard from some folks who, for instance, clean these rental properties, and that will significantly impact their businesses. It will significantly impact other local businesses who rely on the turnover of people that come through the area on a tourism basis in their businesses. I'm speculating, but if the objective is to curtail problem renters by reducing the number of available properties to rent in a given week, there's no evidence that it'll achieve this objective. What I did hear at the February meeting from your enforcement officer was that last year there were a handful of reported issues with renters prior to these amendments, and that those were limited to 1 or 2 hosts that were problems exclusively. And so, the proposed amendment to limit the cycle of renters would seek to penalize 99.9% of all the other owners to the tune of tens of thousands of dollars potentially, who are operating under the present ordinance without incident or complaint. And it seems patently unfair, and it really is the single most incentive within these proposed ordinance amendments for owners that I represent, to potentially challenge the ordinance. To my knowledge, there have been no legislative findings by this body or findings of any kind that would justify this particular added restriction in the ordinance, and that it's our position that it would not be a reasonable exercise of authority granted under law to the board, because it addresses what we discovered at the February meeting to be an insignificant or very limited concern involving 1 or 2 properties and just a handful of complaints. So, we would ask that the board pay particular attention to this particular item in their continuing deliberations. Finally, it was raised and discussed at the last meeting that there was really no justification, on the record at least, to establish the proposed 2.5% cap relative to the housing stock for short-term rental licenses. Subsequent to the February meeting, I provided the board a letter with an article attached, which indicated that, the neighboring county, which is Leelanau County, of those municipalities who have short-term rental regulations, that the average cap was a 6.4% of housing stock limitation in Leelanau County. And so again, there simply doesn't appear to be any justification in the record at this point to support the 2.5% cap, which we would respectfully request the board to review and consider in a meaningful way when establishing that number. I want to thank the board again for its time. I know that you are working hard. We appreciate you scheduling something on a Wednesday night. I know you don't get extra credit for attending extra meetings, and so I know you're working hard to resolve all of these issues that people are presenting to you. I don't envy you, but I appreciate your time. Thanks.
Thank you. Sir?
Good evening. I'm here on behalf of my client who's on Spider Lake. And I would first like to say that don't bemoan yourself the timekeeping. I've been in courtrooms that have spent a lot more on timekeeping, and they know a way worse job than Miss Wendling over there.
What was your name, please?
Christopher Ackland.
Thank you.
And I'm not going to discuss the greater issues here regarding the ordinance and any deal, other than to give some observations that I've had in dealing with other townships. This is obviously an issue among many townships. And what I've seen in dealing with this is that it's often better to use a scalpel than a hatchet on these things. And I'm glad to see through looking and doing some research on this that you guys have been taking the time to look through these and try and find meaningful solutions. As it's been pointed out, it doesn't appear that this is an all-encompassing issue in terms of every property, but that these need to be tailor-made solutions. And so I would encourage you to keep doing what you've been doing and trying to find those solutions. The reason I'm here primarily is in looking at the moratorium and how it's affected people that may have either been unable to or hadn't been able to renew their license before the moratorium hit. And while certainly we understand the township's desire to maintain their regulations and all of their enforcement, the way that it appears that this was handled and looking at the procedures and processes that were in place, it did bring me concern that there may have been issues regarding the process that was done and how it may completely divest certain people of their ability to utilize their property for the purposes which it was purchased, and to the use that would be in their best interest and in the best interest of the property, and frankly in the best interest of the township. We've heard about the economic impacts of this, and by removing people that, in my client in particular, he spent all of his time trying to make sure that he is maintaining compliance with codes. He's recently redone his septic system. He's always maintained communication with his renters as to what their responsibilities are as renters to not cause any damage or harm or obfuscation to the people around them. And so it was concerning when I was looking at the process, and it appeared that he wasn't provided notification of the matter in a time where he could have complied. And so it did appear that you guys have taken notice of this issue, and there may have been some looking at working with people that may have been in that situation to try and see if they can get them renewed and at least on the same level where they would have been before. And I would encourage the township to continue with those efforts, because allowing a complete divestiture of somebody based on a process where there may have been notice issues, where there may have been process issues, certainly can be problematic at best. And therefore, I would respectfully ask the township to take that into consideration and look at adding a grace period for people that may need to renew their license that had previously been in compliance.
Thank you. Next, please.
Sam Flamont, I own a house at 933 Juniper. We do use it as a short-term rental. We have actually had more problems with our neighbor than our neighbor has had with us. And the real issue here is there's a middle ground. And I sympathize with both sides of this. And I don't think anybody's all the way right or anybody's all the way wrong. I do have a problem with the 7-day minimum. And I have a problem with a lot of these changes, especially the one about not being able to sell your house as a short-term rental that you bought as a short-term rental. So when there was no real ordinance and we came here and we put together the ordinance that allowed people to go out and buy a property as a short-term rental, when they purchased that property, they were under the understanding that they could sell that as a short-term rental. And so were the people that were selling the houses. They understood they had a higher property value and the values went up. Yes, the values will go down. Fortunately for me, I bought the property at a certain number that it won't even affect me there, so I don't care about the moratoriums so much. I care about the 7-night minimums because that will absolutely destroy the businesses. These are businesses. These are local. I mean, I live a mile from the rental property. I'm there. People know me. The neighbors have our phone numbers. We simply need to be able to operate the business as a business, because that was purchased for, and we did it legally. We were told we could do it, and we did it. So I understand that that neighborhood has a lot of short-term rentals, ours being one of them. I also understand that we went about this process in a legal way. We didn't break the rules, we got a permit, we did everything that we're supposed to do. We even fenced in our backyard to make sure if people brought dogs, they couldn't get out, because we don't want to be a nuisance. At the end of the day, I heard someone say it's not the township's right to protect my business investment, right? If I bought a short-term rental and the township wants to take it away, too bad for me. Well, that's the same as saying what Traverse City tried to do downtown when they tried to say no office space on the first floor. That didn't go over very well, because it makes common sense that if I bought a commercial building 20 years ago and had office space in it, and I want to keep office space in it, why would you take that away from me? I bought it that way, it should stay that way. So if you own a short-term rental, you should definitely be grandfathered in to the rules that are there. The 4 nights, not the 7. You should not have to be worried about losing your property because you're too close to somebody else. But more than anything else, it's just simply that if you're not following the rules, you should go. I agree with everybody who said that. If you have a bunch of bad tenants, we actually manage other rentals. Of the 70 rentals that we manage on top of the ones we own, we've had 1 complaint over the course of 2.5 years. That's a lot of stays, a lot of nights. We've had 1 complaint. We handled it, we talked to the neighbor. It was no problem after that. They had our phone number. We said, call us, we're sorry, we apologize. Never had a problem, because again, it's about understanding who you're renting to, letting them know the rules up front. And if you do that, you are a respectful, responsible owner. I've lived next to long-term rentals that I've had real bad issues with and you can't get rid of. I've lived next to neighbors that have owned their house and have been horrible nuisances. They would come onto our property, let their dogs poop on my property. I couldn't do anything. I could only call the township, and they didn't send out the police to come investigate a poop investigation. So we just got to be careful of who we're renting to and what we're doing. But we can't just take all this action and affect as many people as we're affecting, especially their livelihoods.
Thank you. Ma'am? Hello.
Hi.
Could you introduce yourself, please?
Yep, just give me a second to find my notes.
Well, you know what? We're going to let the person behind you go ahead of you until you're ready.
Oh, I'm ready.
Introduce yourself, please.
Okay. My name is Sarah Charneski, and I live at 4452 North Spider Lake Road. My husband and I have both dreamt about owning a lake house since we were children. We were fortunate enough to start looking for a home, and after 2 years of searching, we decided that we love the Spider Lake area, and we were fortunate enough to buy a home in 2021. To say the home was a fixer-upper is to put it lightly, but we have literally poured our blood, sweat, and tears and a lot of our finances into revitalizing this space. We aren't old enough to have purchased a home here 20 years ago or more, when housing was more affordable, and we weren't fortunate enough to have parents who gave us one. So we had to figure this out on our own. As people in our 30s today, retirement seems quite a bit more unsure for us than it was for our parents' generation. Our rental is part of that plan, and we hope to rent until we're able to retire and move into this community with children we hope to have soon. Another part of that retirement plan is the cleaning business I started last year that serves many of the rental properties in our area, and is providing a real income for myself. While I understand that STRs may be affecting some neighborhoods negatively, I am one of the 3 houses located between 2 resorts that have been there longer than any of the homeowners. So everyone in our area knows what we signed up for living there. We actually have great neighbors who we have great relationships with, some of which are lifetime residents. We enjoy the lake together, we enjoy meals together in each other's homes, we go out in town for nights out, and we help each other on our projects in our homes when someone needs a hand. So
some of the proposed regulations, especially the 7-night minimum, could really seriously impact the future of my young family and our ability to remain a part of this community that we have grown to love and hope to be a part of in the future.
Thank you.
Hi, I'm Mitchell Treadwell. I've already said that I'm a Traverse City resident. I am also a Traverse City commissioner and planning commissioner. Traverse City spent years trying to draft and then refine our short-term rental ordinance. And I'm not suggesting that East Bay Township just copy what we did. In fact, I am a strong proponent of local control in determining what ordinances work well for your communities. Unfortunately, East Bay Township finds itself in a position where it allowed short-term rentals without as fine a tooth on the ordinance language, and now you're having problems, particularly as we hear about in the Pine Grove neighborhood and the Lake area. Pine Grove, yes, it's East Bay Township, but it is functionally another neighborhood of Traverse City in terms of it's all Traverse City addresses, it's on Traverse City utilities, people go to Traverse City schools, and if you don't live in the neighborhood, you might not know exactly where the city limit is, just because you've got single-family housing on one side, single-family housing on the other side, with streets that go seamlessly between them. But it is important to preserve a historic, quiet neighborhood like Pine Grove as primarily residential in character, and I would hope be gearing towards long-term residents. Along the US 31 and East Bay corridor, you have clearly separated in your zoning maps between the area to the west of 3 Mile as predominantly residential in character, and the area to the east of 3 Mile as being more commercial in character and having more businesses, restaurants, hotels, and the like. One thing that we have discovered in Traverse City, and as we look to refine, as we have a couple times and as we may in the future, ordinances about short-term rentals, is having a clear demarcation between what is a residential use and what is a lodging use. Short-term rentals, although it is still a residential unit that is being rented, is functionally much more like a hotel than it is like a rental unit that somebody is using for 6 months, a year at a time. And along that west of 3 Mile area, you have hotels that I would say if a developer wanted to build a condo or take an existing condo complex and treat it all as short-term rentals, that would be in keeping with overall character of that area. In the lakes part of the township, it's a little trickier because you have
Can you wrap up, Mitch?
yeah,
Thank
you have had historic resorts there, but I would look to be very careful about how you balance those long-term community needs.
Thank you. Hello, how are you?
Well, thank you. My name is Michelle Whitcup. I'm at 823 Indian Trail Boulevard. And I don't have any comments on the regulations itself, but one thing that we notice in Pine Grove, highly dense, we see a huge traffic change when we have high capacity and all of our, I shouldn't say all, I can't speak to that, but a lot of our short-term rentals are filled. And it becomes like a speedway. So one thing I would ask is that you consider some type of traffic calming in our area. There's not a stop sign from Avenue E until 3 Mile. And if you're trying to walk in the evening, I've literally been forced off the road by cars going so fast. And you think about, call the police, they're gone. They're already gone. But what can we do in those areas for traffic calming to help just decrease the speed of people? And I, of course, I can't say 100%. These are all short-termers. They might be locals,
But what can we do for those areas where there are a lot of people, whether they're cutting through, whether they're short-term rentals, or whether they're just locals? But can we do something for traffic calming? And then on top of that, when you have all of those buses coming, our roads are horrible. Now, I can't, again, speak to this from other places, but when I see those buses coming and I look at the potholes and I see the businesses that are on that area too, the potholes on our Pine Grove, and Pine Grove doesn't even have a stop sign. And again, just flying through there. So that's just something I would ask you on the high-capacity areas to consider is something from a traffic calming perspective. And I know it's not in your ordinance, I don't expect it to be in your ordinance, but maybe it's something you do outside of that. Thank you.
Thank you. Okay. I don't see any other further public comment, so we will close public comment at 8:40. And does anybody from the board need a break? You okay? All right, well, we will roll on then. We'll bring this back to the board for discussion. Claire, would you come on up? Sue, would you, I was just going to see if you might grab that microphone and put it in the middle of the table there for Claire. Thank you. You can introduce Jacob too. So Claire, if you would take us through some of the changes that we're seeing in here that were from last month, and also introduce yourself and Jake.
Okay, good evening. Claire Carner, Director of Planning and Zoning with the Township. We've got Jake Whitty here is our consultant legal counsel that's assisting with the ordinance update with Fahey Schultz, and then we also have Preston Taylor here, the zoning administrator. So do you want me to just go through the materials that we have in the packet?
Yeah, that sounds good.
You'll see that based on the last time the township reviewed the ordinance, it was February of 2023, there was guidance to staff on edits to the draft amendment. That's edits to Ordinance 5 of 2019. So you'll see that there is updates to that ordinance. The changes that have been made since February are in red, and they're summarized in your packet in the memo on page 21. Then there's also edits to the draft policy that was presented, and that draft policy is related to the noticing once short-term rentals become available. There was also discussion about some of the lapsed licenses that have come to the attention of the township. Staff brought it to the attention of the board, and so the board requested that staff take a look at how many licenses we're talking about and present some policy options for the board's consideration. So you'll see that there's a memo summarizing that, policy options. And then the fourth item or memo that is in your packet, and that was added yesterday, is a summary of housing units in East Bay Township, both existing housing units with some justification based on assessing and the U.S. Census data about housing units and the percentages that we're using. In addition, we summarize the new housing units that have been approved by the township, both multifamily and single family, both those that are under construction and that have been approved through site plan review, just for you to take a look at kind of what's coming down the pipe, and if the board continues to keep a certain percentage of total housing stock relative to short-term rentals, then that would be something that the board would reevaluate on some regular basis to ensure that percentage is consistent as we see more housing developed.
Okay, very good, thank you. Jake, did you have anything specific to say before we start to take a look at some of these things?
I can walk through some of the changes if that would be helpful for you guys.
I do think some comments were already included in the packet. I guess some things that I would like to have specific board attention to. So one of the larger aspects that was changed was essentially a cure period for violations of the short-term rental ordinance discovered when a license is being renewed. And so that would be helpful to have some board input on. And then otherwise, unless there's specific questions, I think we can just kind of go through it and I can answer them as they come up.
Okay, first I wanted to hit just up on a couple misconceptions. With respect to when we hear grandfathering, there are two types of ordinances, a zoning ordinance and a general law ordinance. This is a general law ordinance, and so there is not grandfathering. When we change this ordinance, all short-term rentals will have to comply with this ordinance. I think what's getting confused with the term grandfathering is just that we are allowing those who had licenses, even though it's potentially above the cap, they are still able to keep those licenses, correct?
Yeah, that is correct. And I think the distinction is that, between a zoning ordinance and a non-zoning ordinance like this, a non-zoning ordinance like the township's ordinance does not have grandfathering as a matter of law. So the township can include certain provisions to extend, privileges or protections to existing licenses, but that's totally optional. That's a policy consideration.
Okay.
So there is, as you're saying, absolutely, you're correct. There's no automatic grandfathering. That doesn't apply to an ordinance like this.
Okay, and then another one, and I'm not saying that there's misconception across the board, but on the 7-day suggestion, that doesn't mean that they can't rent for less than 7 days. You could absolutely have somebody stay for 2 days, charge them for 2 days, rent for 2 days, but it's the frequency of turnover of parties that would be a 7-day limitation, correct?
Yeah, that's how the ordinance is drafted right now.
Okay, and the other thing is, I did want to mention, correct me if any on the board, one that short-term rentals don't pay into infrastructure or things. Obviously, if they're on sewer and water, they do so. Tracy, they pay property taxes, most of which are not homesteaded, so they're paying that 18 mills for the.
So they actually pay for the schools, not the homesteaded properties.
Right, okay. And then, as far as being able to transfer the license, our original ordinance, our existing ordinance does not allow for that transfer of license. So that part is not changing, correct?
So we've looked at some exceptions for transferring, and actually, this is something I wanted to bring up. So I've had the opportunity to talk to an attorney in my office who specializes in tax law and has some ideas at how we can come up with a transfer process that is going to be kind of equitable and hopefully achieves what the board is looking for. Because I do understand that there is, at least at the time being, a desire to allow transfers to immediate family members. And to circle back, I agree with you that under the previous ordinance, you'd have to apply for a new application if you wanted to transfer. But on the topic of transfers, I do think that as presented, the ordinance still needs a little bit of work, specifically, and I think someone in the public picked this out as well, as it pertains to trusts. And I think there's also a little bit of additional detail that could be given to this process to make sure that it's something that's actually easy for the township to monitor and enforce.
Okay. Just one last misconception. I believe there's a misconception that the reason that the township's looking at ordinance amendments is because there's been some huge specific issue or specific groups of issues. The truth is that staff has just introspectively noticed that, just like every other community across the nation and really internationally is contemplating and even in some cases struggling with short-term rentals, staff looked at it and said, how is this affecting the preservation of neighborhoods, and are we impacting the housing stock and the price of housing and those impacts? And so that was brought to the township based on that rather than in any specific complaints, correct, Claire?
That's correct, and at the beginning of this process, we worked with legal counsel to compile pretty detailed data on the existing housing stock, the existing long-term rental supply, the opportunities for short-term rentals, the opportunities for long-term rentals, the housing prices, kind of looking at trends to help inform this ordinance amendment. And so these, we did work to have the draft amendments reflect the trends that we're seeing and some of the challenges with that proliferation of short-term rental uses in established neighborhoods.
Okay, with that, Jake, I think we're going to, if the board's comfortable with this, we'll keep the discussion about the 20-some-odd licenses for after. We'll keep this right now to the ordinance and deal with that first, and then we'll delve into the other. So, and Jake or Claire, it's fine if you just want to go through that detail and hit the high points of those items and where you might need more feedback. Again, Jake, that would be fine.
Yeah, sure.
Can you turn his volume up just a little?
I'm sorry, was that a comment?
Oh, I was just asking Claire if she could turn your volume up just a little bit.
Oh, sorry, and I'll try to speak up as best I can too as well.
Well, we know you have a newborn in the house too, so.
I haven't heard her in a minute, and so there's a good chance she's sleeping, so I don't want to jeopardize that, but I'll do what I can for you guys. So the first change was to section 6C. We kind of explored a few different options for occupancy. And the feedback I got from the board last time was that the kind of graduated sliding scale of occupancy was too complex and probably too difficult for people to understand, which that does make sense to me. So the revised language that we have now is substantially cleaned up. It's 2 occupants per bedroom plus an additional 4 occupants, and then there is a restriction on visitors equal to 1.5 times the number of occupants. And that is based on, bedrooms that the sewer system is designed to handle.
Okay, I think we're all clear with that. Any questions from the board on that?
Did we select the hours, 8 a.m. to 11 p.m.?
I don't know that we had hours on our original ordinance.
No, this is new because the visitors is a new provision.
Okay, I think, some people from the HOAs on the Lake Association might know, is there a quiet hour time with the HOAs? 7 to 11, 7 a.m., 11 p.m. 7 p.m. to 11 a.m. Oh, okay, I thought it.
That's late quiet hours.
Oh, I thought it was like 10 p.m.
No, it's just on the water. Like you can't have wake,
Oh, for the 7 to
boating wake from 7 p.m. to
11.
11.
And I wasn't talking about the wake, I was talking about like quiet hours.
But that's
in
what they
the-
consider quiet hours.
Got it, okay,
Because the engines aren't revving on the lake.
okay. All right, so is there any response back? The hours from 8 to 11 could be altered then, Jake, correct?
Yeah, absolutely. There's no magic legal formula for what's appropriate there. It's just really a policy decision as to.
Any
when it
direction on
would
the
be.
board? No comments? 8 to 11?
I think 11 is a little late, especially during the week. when most people have to get up and go to work the next day.
I would agree with that. I just heard you say you would
Yeah,
agree.
yeah, I would agree. I mean, I don't know, somewhere between 9 and 10
Yeah.
probably seems a little more appropriate.
Sure. And 8 a.m. seemed
And
fine?
we're just talking about visitors too, right?
Right,
Yeah.
right. 8 a.m. seems fine?
Yeah.
So how about 8, we are specifically talking about visitors. So 8 a.m. to 10 p.m.? Is that fine? Okay. Are you good with 10?
Yeah, that's fine.
Okay. That kind of, so there's some groundbreaking change for you, Jake.
We can make that change. So if nothing else needs to be discussed about the occupancy restrictions, next change was to 6F, and that was just to note that parking needs to happen in areas designated for parking. I believe one of the requirements is some kind of site drawing or site plan submission, not a formal site plan, but some depiction of the short-term rental premises. Presumably that shows parking. This says that parking can't be on the yard. It has to be in areas designated for parking. Questions on this change?
Does that not designate then yard area? I mean,
It could be yard area that they designate as parking.
that's what I'm wondering.
That's what I think you're getting.
Yeah, does this really limit them from when they turn in their site plan from declaring a yard as a parking area?
Not necessarily, and I guess this again kind of comes to a policy decision. If the board wants to put more onerous requirements on parking to, have it be on a hard surface or so on and so forth, that's an option. I will say that Section 6F as written, I believe it forbids, parking in the right of way. So all of it has to be on the short-term rental premise. So,
Yep.
there's only so many vehicles you can fit on a parcel. And especially you couple that with occupancy limits, I guess this is, maybe there are aesthetic concerns or they're going to be tearing up the yard or something like that, but they do have to be only on the short-term rental property.
Okay, any comments or questions from the board?
Can we back up one on septic?
Well, let's finish this one and then we'll go back to septic, okay? Okay, any questions or concerns on the way it's currently worded for parking? I guess my first concern would be like, do you just load up the front yard and the driveway with parking? But I also think that there's tremendous, they have tremendous investment and value in, keep not tearing up that front yard. I mean, just like anybody else, so. Right, or their septic system. So I mean, I think that that's enough guidance that if we have some real huge issues that we can work with that. Okay, so let's go back to septic, Glenn.
Okay, the one thing I wanted to ask a question about.
What section are you on?
All septic systems are.
What number and letter?
Back up to C.
C.
C1?
C1.
Okay.
Oh, okay.
Okay, the question I have is, I'm assuming that all septic systems aren't the same, especially around the lakes, because if they're older. And if the health department said that the septic system was good for 2 bedrooms, and we're gonna double the price or the number over that, is that gonna create a problem with the septic system? I mean, if you got 2 bedrooms, 2 each in a bedroom, that's 4 people. If that's what the septic system was designed for, and the capacity, and then you throw another 4 people in there, is that gonna create a problem? That's my
Yeah.
question.
I mean, I guess that's a good thought. That's a good point. The thing that I think of personally is just knowing how a lot of the rentals work in your families. That overflow of 4 people that tend to be in bunk beds are usually kids. or lots of times, children. And then the other point is that while a home is 24/7, 365, these are rentals that have some periods of non-activity. So I think that may weigh out in the end, or average out in the end.
Well, what I was looking at, they're talking about backing these one right after another in there, which would be similar to what a regular resident is.
Full-time.
But is the septic system gonna be the same out around the lakes as what it is in a residential setting?
Yeah,
That was my point.
yeah.
Do we know if the health department, I know they base it on bedrooms, do they base a bedroom on 2 occupants?
I don't know.
I'm not
just saying.
sure, I don't know, but that might answer some of your question, because,
That was my understanding in talking with the health department, and they had recommended looking at Long Lake Township, that they kind of worked with on having a little bit more restrictive provision in their short-term rental ordinance, which is kind of how we started down this path of stating specifically that the number of occupants shall be 2 per each bedroom, that the septic system is designed to accommodate by the health department.
Okay.
So Long Lake Township doesn't have that +4 additional. They cap it just at that, what the health department. And I think we started there, and then the board direction was to add more.
Which
Yeah,
is our-
this is the calculation we've used since the beginning.
Right, right. Yeah, because our ordinance right now has an additional 4.
We say 2 per bedroom plus
Plus
4.
4,
This
yeah.
adds the
The
statement
health
about the
department, yeah. Okay, thank you.
Okay, Jake, you want to go ahead on from where you were at?
Yeah, next change was pretty minor, but I do have some information to share with the board relative to this one. So this is 6P. We talked about, how are we measuring the separation distance? We decided that this should be the address point as defined by the Grand Traverse County Equalization Department. Or I guess a better way of putting it would be as established by the Grand Traverse County Equalization Department. So I did make contact with the Equalization Department because I think there were some questions about how that point is established and how would we be measuring from it. And what I found is that there is a very complex and scientific way in which the Equalization Department assigns address numbers. But the address point is basically someone clicks on the GIS overlay where a building is, and that single point is where emergency services are routed to. So there's not really any scientific formula for how the address point is located within a structure other than that it is located over the structure. But with that said, it is going to be a much more permissive way of measuring the separation distance than to do it from the property line. And I think the benefit is that those address points, those are available online. It's not something where the Office of Zoning and Planning has to, get on Google Maps or something and measure the distance, wall to wall between 2 buildings. So that's the way that point is established. I don't really think that the fact that it's not centered perfectly in a structure is something that's too concerning, because it's still giving you a single point of separation from where the principal structure on the property is located.
That plus, we could educate Equalization Department to strategically pick where they're putting their cursor as well. That is an option.
We could absolutely encourage them to try to place their cursor more strategically. And honestly, after talking with them, I think they'd be receptive to that. They were very helpful and friendly people.
Okay. What is the board's direction on that, or feedback?
I would think that we just use the property line itself, not the address.
No, I'm the one that brought this up, because out in the rural part of the township, if you got a 40-acre parcel and you measure from line to line, houses could be a long ways apart, and now you're penalizing them. They may be a half mile apart, and yet they can't because their property lines touch each other. Because that's the way it works. But if you use the access point, it's from that house to the next house. It's not going to make a lot of difference. I mean, a standard house is 24 to 30 feet wide. So if you're off by half of it, you're 15 feet, and then it's to the point of the next house. Who knows? They may be on opposite sides. You might actually add to it. So I don't see a problem with it.
Yeah, I mean, I think in general, could there be a problem? Maybe one, and how many? It doesn't seem like it, and it seems like it's the best option that we have, other than if we just, the thing that came to my mind was just using the point of the primary entrance.
So what your thought was, is the center of the house is your measuring point?
Well, yeah, but the GSI just, what they're saying is if this is my house,
Yeah.
they might put the point here.
Yeah.
It's very little difference
Right.
from 1,000 feet.
Right.
What it's going to make to the next,
Exactly.
next point. So
Let's
I
ask
don't see the
Preston.
problem with it.
Preston?
Preston
It's just
here?
an arbitrary number anyhow.
Oh, Preston, did you have a preference or input on that? See, I'm not the one who called you with a question this time. He said to me today, are you going to ask me anything without giving me warning?
Warning, sorry.
My preference would be the address point that's noted through GIS, which
Okay.
I was told is basically on top of the roof. Center of the roof is what they try to go for.
Okay. All right, very good. Is the board comfortable with that?
Yeah.
Okay, so we'll just keep that, Jacob. All right, we'll move on.
Sure. Section 7, there are some kind of notable changes here. So this is the renewal provisions. We have a new subsection E, which contemplates short-term rental properties that don't comply with all the ordinance requirements at the time of renewal. And I think there was concern previously that I think the example was if you had some kind of problem with your septic system, your license would just basically be revoked at the time of renewal if it wasn't up to the standards of the ordinance. So with that hypothetical in mind, what this does is create kind of a 60-day cure period in which once a short-term rental license holder is notified that some aspect of their operation doesn't comply with all the requirements of the ordinance, they have 60 days to cure that problem and then come back and then have the Office of Planning and Zoning verify that they're in full compliance, and then the renewal will be issued.
I guess I have one. I'm thinking, that can be used for other things too. Let's just say the fire department's called there and finds that they don't have working, smoke alarms. So, they let us know, and so there'd be an issue. They need to get them in within 60 days. But specific with the septic tanks and fields, I'm wondering about the 60 days. I mean, that could happen in December, which would be...
So a couple things there. First off, 60 days is a placeholder. That was something I picked as kind of just a default, but that's up to the board. The second thing is the 60-day can be extended upon good cause shown, provided that the license holder, puts that request in writing and gives it to the Office of Planning and Zoning before the end of the cure period. So if it is December and, it's going to take you 4 or 5 months to get someone to come fix your septic system, you can explain in writing, give that to the Office of Planning and Zoning, and they can say, okay, we're going to extend until whenever the contractor can come out and fix your septic field.
That's right. I'm sorry. I think we did talk about that before, and I just missed that detail, so thank you. Go ahead.
So can we talk about the 60 days?
Sure.
Because I think that's a little long for a smoke detector. So I'm wondering, because it can be extended, and I think if the problem is a septic system and it is blatant that it's going to take more than 60 days or 30 days, would it be,
You're thinking
One
30
quick
days?
comment.
yeah, would it be smarter to do it less time to begin with, and then, I mean, Preston's going to be the one that extends that, so if it's a septic, he knows it's, nobody's going to get out there in 30 days, even in the dead of summer, they might not. But if that would trigger communication with the owner,
Make it more emergent.
yeah, I just think, 60 days could be how many rentals with no smoke alarms?
Okay.
So one thing I probably should have explained better is under this provision, as soon as it's discovered that the short-term rental is not meeting one of these requirements, all rental activity has to cease.
Oh, okay.
So
I saw that
60
someplace
days
else, but
is
I
kind
didn't
of
see it
long,
here.
but I don't think they're going to be dragging their feet because they're not allowed to rent until the deficiency is resolved.
Right.
Okay. Good point, thank you.
I was just going to say something on
Oh,
the
immediately
septic.
ceased.
If the septic failed, number one, the first thing they should have to do is get a pump truck out there and pump it, and then pump it every 2 weeks or whatever somebody says according to the size of the tank until it is fixed. Or they can't rent it. I mean,
Well,
Well,
and
this is
says
saying
it-
they wouldn't be able to rent
yeah,
it.
I didn't see that. I kept looking. It said rental would cease until it can be fixed.
Okay.
No rentals as long as there's a deficiency.
Right.
And if they are a failed septic system, then they fall under the purview of the health department, too.
Right, yeah.
Okay. Okay, good. All right, thank you. Go ahead,
So do
Jake.
we want to leave it at 60 or 30?
Oh, what's the board's pleasure?
I don't have a problem with 60 myself. I know it seems like a long time, but you're stuck in that situation. Sometimes it just takes time. And you can't, as it says, you can't rent it for that period of time, so.
And you can remedy it quicker than 60, but it gives you 60.
Okay.
Did you have any input, PT?
I would concur with what you guys are.
Okay. All right, so we'll leave that at 60? Okay. Well, go ahead, Jake.
Okay, last change to the ordinance was a minor correction to section 11 transfer. Just to add sibling, as I indicated earlier, I think, I know this is kind of where we landed, but I think we owe it to give a little bit of a closer look to the transfer provisions, and there's actually some discussions I'd like to have with the township assessor to see if there is a better way to establish rules for transfers, maybe mirroring the restrictions for uncapping in the Property Tax Act. So I guess unless there's specific direction or changes the board wants to have, I guess I would leave it to expect more changes the next time you see this ordinance.
I think that's kind of what I was talking about last time, is to mirror that, what the assessing uses for the uncapping and the transfer, the acceptable transfer of properties.
Yeah, and those provisions also do have restrictions on trusts,
Yeah.
which is something, and like I said, I think someone pointed that out earlier, but that is something that's not really covered by the ordinance or its transfer provisions right now.
Okay. Yes, go ahead.
What would that do on a corporation that owns a short-term rental? Because I don't believe they can transfer it to family. They're a corporation. But I don't know for sure. Somebody had brought that up tonight, and I thought, yeah, what do you do with corporate? That's the business part, like a hotel down on the strip. A corporation, I can't believe you'd have a business, you transfer, and it doesn't come on cap.
There
With
is,
the express disclaimer that I'm not a tax attorney, my understanding is that a corporation can transfer, I think, either up to or less than 50% ownership interest in the corporation without it constituting a transfer.
which would be a question or something that I think our assessing could help with that as well, Because I know, like, for an LLC, there is documentation that you can do when you set it up, so that they identify who the members are as individuals, and then they can transfer to their family, immediate family, and not become uncapped, is what I've learned.
Depends on the percentage, I believe, on some of it. Are you talking like land? Oh, no, I'm thinking land division, sorry.
Yeah.
Anyway,
That's something that assessing can.
yep. We will hold that for further information and maybe for some best practice suggestions from Jake. Okay. And was that the last change you had to go over, Jake?
I believe so, yeah. There were some very minor changes to the short-term rental policy, but that pretty much wraps up what we've done.
Okay, so I'm going to stick with the ordinance here for a second. Just going back to make sure we're okay with all the redlined areas. And I don't anticipate that any board member has an issue with, and if you do, let me know, any of the definitions, the changes with the definitions. And let's see, that section B1 will depend on that further analysis from Jake. And then we have talked previously about the section 16, which is the septic tanks, and gotten feedback and information from the health department. I did want to, am I skipping over anything anyone wants to stop on?
I will say, we're going to need a minor change in the definition section if we're going to change visitors from 8 to 11 to 8 to 10.
Okay, yep.
Yeah.
Yep. Let's see, I also did, let's see, the next red line change we have, having gone through page 13, oh, our footers got messed up on this, but anyway.
13 of the packet or 13 of the ordinance?
Of the ordinance, 14 of the ordinance. In addition, to be eligible for a short-term rental license, applicants must have no outstanding issues with taxes, permits, inspection fees, escrow, or amounts due and owing to the township. And I'm assuming there's no issues, right, with that?
It's similar to what we have for permitting and stuff already, so I thought that needed to be in.
Okay. I did want to just discuss a bit the F, which is the total number of licenses, because at the last meeting, I think we talked about that housing stock number. So Claire, do you want to go over how you determine that? And I know you were going back to redetermine to make sure it was a formula that you could recalculate.
So it's based on 5,800 total dwelling units in East Bay Township. So that's the 2.5%, which got us to 145 licenses. I had worked with assessing previously to pull all of the assessing records, basically everything with a residential building code. It got a little bit complicated because residential building codes included like the Tamarack Lodge and a lot of the timeshares, the resort condominiums along US 31. Those function much more like a hotel, so we removed those. But then the like Wood Creek and manufactured housing community that are single-family homes are not residential, don't have a residential building code. So it took a little bit of kind of calculation to come up with the housing units. When I had assessing take another look at it, remove all of those resort condominiums, and then add back in the existing Wood Creek manufactured housing community, we are at about 5,568, so about 5,600 housing units. We also looked at the census government website, census.gov, East Bay Township is listed as having 5,679 housing units, but that margin of error is 281. And that's pretty typical with the census, especially with the population the size of East Bay Township. So that's a range of total housing units of 5,400 to about 6,000. So I'm pretty comfortable with that 5,800 estimate, especially given the fact that we have 800 new housing units in the pipeline right now. And you'll see that that's covered in the second section.
Question on that. The total number in the new housing unit, what did you come up with which are being built and what are on paper, maybe not approved
On
yet
the-
for a total?
On the horizon, yeah, so there are,
I might have added wrong. I come up with 1,231.
oh, for total?
Yeah.
Yeah, that's very close. So when you take the total of 539 that are under construction, plus an additional 238 that have been approved through site plan review, but have not yet received a land use permit, and then are you adding the additional, like 414?
Right.
That have not been approved, but they've come before the planning commission as potential projects?
Well, my concern is when I figured out the 1,231, that's 30 permits more. And a lot of them, I gotta believe that it's like up in Holiday Hills, they're not allowed to have short-term rentals. And I'm assuming that some of these are probably not gonna be allowed to. Is there a way we'd either have to drop back to say 2%, or is there a way to pick the projects that are through their deed restrictions are not allowed to use them for short-term rentals and not count those into it when we figure out?
That's a possibility. Right now, the total housing units that we're looking at include quite a few that are deed restricted in our current formula, because we've got most of Holiday Hills that are deed restricted.
Right.
So that would be a different approach.
Well, the thing is that if we're talking about lowering the number of short-term rentals, and we look at all this that's either been approved or the paper's drawn up, they haven't been approved yet, we're right back where we're starting. And that was my concern. And maybe the easiest way is to not count the units that are not available to be used as short-term rentals into the total number. Just
The other thing that I've seen in some communities is that they don't allow short-term rentals in multifamily, and so that reduces a lot of what we've approved recently.
I was going to say, we all already have short-term rentals in multifamily
That would be a
units.
different situation.
Yeah,
And the 1,000 foot will affect those
Right,
in the future.
automatically, yeah.
Mhm. Not our current number. And one point I'll make, Glenn, is when we're looking at like that 145 number, it's not that we're going to say there's only going to be 145 licenses. We've been down this road already in 2019. We already have more than those licenses. That 145 is a target or a vision of where we want to get to. It'll be through attrition in doing that.
Right.
Yeah. But I just wanted to clarify that it's not like we're taking it down to,
right.
We're not-
I'm
yeah.
sorry. Yes, I know.
Yeah.
Probably I won't, none of us will be sitting here if it ever gets to 145, because it's gonna take so long to get there.
true, it could.
But my concern is, it's just like what was brought up, where you got them 2 or 3 short-term rentals right around, in one little area. That's my concern.
Yeah, and I think the one thing that we're doing that'll make the biggest impact on that will be the 1,000 foot.
But
That
if
will
we're
help.
already there, though,
Yes, understood.
okay.
Well, to Glenn's point, my opinion, and I think we talked about this last time, is the deed restricted housing units should be taken out of the equation. Now, granted, that's going to take our our cap at 145 based on a smaller number is going to increase that percentage. But I think the math needs to be appropriate because all this could be for naught when the board changes eventually. There's going to be a
Right.
change in the makeup of this board. There's
They
going to be
can
another 1,000 or 2,000 units 5 or 10 years from now built in the township, and somebody's going to look back and say, hey, y'all are targeting 2.5% based on total housing units. We got a lot more housing units. We need to build some more. Well, guess where all those new licenses are going to go? Back to those same neighborhoods. So we're going to be in this vicious cycle of never kind of achieving what we're trying to accomplish now.
Well, and the board can change, I mean, these are only as good as
Well, that's what I'm saying.
decision.
We're basically laying the framework with the math here to justify that conversation to take place in the future based on bad numbers.
I do think, though, that, the township doesn't enforce deed restrictions, and so I think that it makes, from a policy standpoint, it makes sense to have justification where you're looking for a percentage of total housing units, as opposed to breaking it up between those with deed restrictions, which we don't have any control over, and those without deed restrictions. So, the deed restrictions are kind of, although we don't issue a license to neighborhoods with deed restrictions, I think we're trying to look more holistically at the whole township and the housing supply in the township and have it.
And I think, probably that impacted one of the reasons they came up with the 2.5%, where they may have come up with a different percentage had they been using a smaller number. That might have been a 3% recommendation or a 3.5% recommendation.
Well, the way that it's building out there, especially in East Bay Township, I don't know, maybe whoever looked at this, there was an area that was already built. They weren't expanding anymore. And that's where they came up with the percentage. I'm assuming it had to come from a total number, but they backed into it with what percentage.
The 2.5?
Yeah.
So I think that staff presented 3 to 4% at the beginning of this process, and the direction we received from the board was to go lower. And so that was where we ended, where we are at the 2.5%.
Right. Yep. Okay.
Well, on the 145, though, is that the number, or is that going to be liquid in the sense that you're talking about 2.5, and you're already talking about another 1,200 homes within a few years? So will the 145 go up?
It would
Based
only
off-
change if the board made, adopted an amendment to the ordinance. So the 145 is what the cap would be. We refer back to a 2.5% to have a basis and a rationale for that number, but the 145 is what would hold the policy weight. So as housing units change, it's not going to be a moving target. It's going to be a board action to make an amendment.
Right, so number one says, which is approximately 2.5% of the housing units within the township.
See, I was
And
under the
then,
impression it'd be the other way, so.
oh, yeah, and then specifically, it says the number 145 in the ordinance. Yeah, did you just gonna say something?
Well, yeah, wouldn't we set an annual reevaluation of that number?
I think we talked about this at the February meeting, and I think you had a recommendation for us, Jake. Or we were starting to really get into the weeds on when, how, why, where.
I thought we already had a solution for this, but now I'm not seeing it.
I didn't see it in here when I read through.
Yeah, so to the extent it's not already in the ordinance, and maybe I'm just remembering incorrectly, but we can certainly say that, this is something the board can revisit from time to time. And if we want more definite language, we can say, the board can review it every year, every 5 years. I mean, take your pick.
I mean, would it
There's
make,
Part 5 says right now, the township board may review and amend this limit on short-term rental license as it determines to be advisable. Such revision shall not be the basis for termination or non-renewal of a license previously issued.
Thank you, Claire.
I
knew it was in there
remember,
somewhere.
oh, sorry, oh, okay. You were nodding your head when I was saying that too. I remember that conversation in February when it was like, don't tie yourself down too much, give the board flexibility on reevaluating that in a time frame.
It changes as these developments complete.
Yeah,
That
right.
number, I mean, 2.5 of the whole becomes a larger number than 145.
Yeah, and it depends on the pacing, like you said, how they come online too, right? So for a long time, East Bay Townships looked at, oh, that's going to be a place where there's a lot of housing growth. And while we've had growth, it's been slower than some other townships. But now we're seeing we've had a lot in the queue at a pretty good pace.
And I believe the census said too, population-wise, they really only captured about 70% of the population for East Bay Township. They know that the numbers they're providing are low.
Yeah.
We could probably do a mid-decade census to capture a better idea of population, but we still have homes that are accurate by building.
So the question is the board is comfortable with the 2.5%? Go ahead.
No, I wasn't, I was just playing with my marker.
Writing in the air.
I write
So-
in the sky.
Are we moving on from section F, where it outlines the 2.5% and the 145?
145 is a solid number, though.
Yeah, correct, it is.
Okay.
It is. Okay.
I kind of feel like that number is low, and
I was surprised. So when we talked about this internally, and initially this was brought to the township board, I was really surprised at the lower number. As Claire mentioned, we talked about 3 to 4%, which is what we've seen a lot of communities do. Not that there's a hard and fast rule. It's to each community to feel what's right. But given the number that we had, I thought that was a pretty low number myself. And that's fine if we want to go for that and do that. As I said, the one thing that makes me comfortable with it is knowing you're not taking those licenses away. That's a target and a vision. So if we want to do that, that's fine. Go ahead.
This is my second meeting of the day. We were here for the subcommittee for the zoning this morning. We spent an hour and a half talking about nonconformities. And I believe it's the third time we've talked about nonconformities in that meeting, at least the second. So what we're doing is we are creating a section of these short-term rentals that don't conform to the ordinance. My feeling is whatever is out there should be the number. After all, they're going to be there anyhow. The 1,000-foot kind of solves some of the problems in the real highly dense areas that if you got 3 in a row and one decides to give up their license, that's not going to be able to be put in that neighborhood for quite a distance from those others. So it ends up being it'll be stuck somewhere else. So the problems that we're having in the lakes and down in the avenues, the density number doesn't solve any problem. I mean, we allow 110 or we allow 240. It still doesn't solve that problem down there because they're pretty much, if you look at the map, they're pretty much built out if you use that 1,000-foot number. So all we're doing is creating a non-conformed use within our township. And that's my personal thought, is that the number should be whatever is existing now, and then it's there, and it's there until this board decides to change it.
Yeah, I get your point, and your point's well taken, that the 1,000-foot distance is really what's going to drive things. The one comment I'll make, though, is when we did see the map with, granted, it wasn't a perfect analogy, but with 1,000-foot distances, the number was quite a bit higher. And I do want to be careful with the terminology. I understand what you're trying to convey with nonconformity, but that's a specific with the zoning ordinance. This wouldn't be a nonconformity, so to speak, but Yeah, any other inputs on the number?
I'm good with the 145. I mean, it's going to take a long time to get to that point. I think that'll be I think to Glenn's point, it'll be if that's too low of a number 10, 15 years from now, then that'll be a challenge probably for that board to deal with.
Yeah.
I think it's still, I mean, I still feel like it's too low if we're not discussing that yet, but if we look at the ones that Preston and Claire had identified that have not, had some problem, whatever issue with renewing, then we're up to, like, I think I added 194. And at that point, I mean, we're pretty much shutting down anybody ever being able to look at getting a license in East Bay, where if we change the number, then there will be a better chance if someone in the future wants to do a short-term rental. You know what, do you understand what I'm saying?
Yeah, kind of. I'm following.
And
you,
we
but I guess
we still have the 1,000-foot that's gonna help with the density eventually.
Yeah, I mean, I just see this kind of as a two-pronged issue. There's the quality of life aspect that we've heard a lot about tonight in some of the more dense areas of the neighborhoods. And then there's the real financial impact to the community and other people that want to move here from a housing shortage issue. So let's not exacerbate the problem by kind of pouring fuel on that issue by allowing more rentals. And as far as like the licenses that didn't make it in or whatever we're going to talk about, sounds like later.
Yeah.
I thought at our last meeting we were talking about a handful, like 2 or 3.
And it was 6, I think.
Yeah, it
that
was
discussed.
a few. So I know we'll talk about that here in a little bit because I think we're at 167, something like that. Total
169.
licenses that are active right now.
68 is what
Oh, okay.
168 is what I thought.
I thought it was, I know on the Excel spreadsheet I looked and it said 170 and there was like one line a header, so anyway, maybe
The last we checked, that was 168.
168. So the rest of the board was talking about the level to set that at, whether that's lower at the 145 or more to actual of what we have or slightly above. Do you have thoughts on that?
Well, I tend to agree that it's low, but I think we still have a much bigger picture to look at. It's not how many we have, it's the education factor for those that live around them, to know how to mitigate those issues, who to call first, those kind of things. It's not going to matter if we have 1 or if we have 168. If someone's waiting until Monday at 7 a.m. to call Preston to say there was a party Saturday night, there's never going to be any resolution with that license holder that is allowing that type of activity to happen. So that's a big part of it, and we haven't really even touched on that. So, I mean, it's kind of pronged. I do agree that this 145 is low because we don't have 145. It will probably be when we are all pushing up daisies when that number becomes 145. Maybe not Matt, because he's quite a bit younger than the rest of us, but.
Hey, I used to be the young one on this board.
Sorry,
What
you were
happened?
replaced. Yeah, so I do believe that is not a realistic number. But enforcement, third-party vendor that is telling us how things are going, those are all big parts of it that have to be discussed. And I don't know that we can just discuss one part without discussing all of it.
So with respect to the number, as long as we're keeping it at or below at some point, it obviously doesn't matter. That 145, like we said, is a target, is a vision. Any future board can change that. I haven't heard anyone here saying they want to raise that over what we have.
I don't believe over what we currently have.
Yes, that's,
Works, but I do believe it's too low.
okay. Was that correct? Okay. So what, the point I'm making is if we have 168 licenses, or 169, no, 168. If we put it at 145 versus 160, it really doesn't matter that much. You're still below where your licenses are. Functionally.
Except that if one of the 160, or the 30 plus
Sell or
that
get
are
rid of it.
above the 145, then someone else can't come and get that license.
Yeah. Yep.
That's the only point I was trying to make.
Yeah. So, I know Mindy, while she didn't tell me specifically, I do know that she was very in favor of the cap. Well, this is what she wanted the first time in 2019 as well, which was the cap was important to her, the 7-day turnover was important to her, and the distance for that density. So it looks like we could have quite a split board depending on that 145. So I think we'll go ahead, Glenn.
No, finish up what you're going to say. I've got a question I want to ask.
Well, I was hoping you had a suggestion.
You know, if you're at 145, we're never going to get there. And the thing is that this thing can be looked at every year if you want to and open it back up and see where we're at. We're not, this ordinance is not something that's going to be unable to be changed. You know, if we figure something out that works better, we want to change the number, we can change it.
Yep, particularly as the housing stock changes.
So
Okay.
then I would suggest that we put a date that we renew it, like when the annual report comes out from the planning commission, or something just something that would trigger us to look at that then.
In other words, open it up,
Annually.
or at least look
Well,
at
at
it.
least look at it and determine whether the number is.
Every
So
year,
it could
2
be,
years?
I think, Jake, we could put something in there that doesn't tie the hands of a future board to necessarily making changes, but just says that they will review such on an annual basis. Could we not?
Yeah, absolutely. That'd be easy to do.
Okay, let's do that. So it's a lot like what we do in like Metro and the bylaws or something like that. Okay.
Can I ask a question then?
Yeah.
And it's, I'm going to guess it's a Jake question. So being that this is an ordinance that requires public hearing and notification, can an amendment be done annually after the meeting that would be done more of a resolution amendment? Or does it have to be a full publication and public hearing?
Has to be an amendment.
Yeah, under the equal dignity doctrine, amendment to the ordinance has to also take the form of an ordinance. However, you could put in the ordinance that the number of the cap will be established by resolution.
So, and we wouldn't have to do ordinances, we don't have to have public hearings, so.
I'm just thinking of the timeline. You know,
Yeah.
it's just,
It's
a
too,
future board can end up with 2 meetings every year that they're just discussing this. You know, I think that ultimately we want to be able to provide something that doesn't have to be changed all the time.
well, I wouldn't have a problem establishing that by resolution. Would
I think that
anyone else?
resolution might be the way to
You
do
can
it.
go by resolution, at least unless something's changed since I was here. Because I think something to do with, and I don't know if it was the annual cost for the water and sewer user fee, and I think that's the way that was done with a resolution back.
Okay.
If I remember, but, you know, it's been a long time for an old guy.
Does anyone here have a problem with the future boards being able to determine that by resolution?
No.
Okay, Jake, we'll go ahead and add that into the verbiage.
Okay, sure. That will take the number of the cap and the percentage out of the ordinance and just reference a resolution.
Okay, and then we'll bring back with this ordinance a resolution that states, at least right now, what we're hearing is at the 145 with that percentage. Okay? All right, the last one going through these, as we hit kind of the high points, was the Section 6B, which is the 7-night period for the rentals. And I did mention, because I do hear a lot of people speak who understand the nuance of that, but I also hear some people use it, and I'm not sure that they understand. It's like, no, someone doesn't have to stay there for 7 days. You don't have to charge them for 7 days. You can rent it for 2 days, 3 days, 4 days, whatever. It's just the frequency of the visitor or the occupants can only change on a 7-day frequency. I do.
It's the first night of the previous, so somebody comes in on Friday, the next person can come in on Friday. The first person could have stayed 7 days, or they could stay 3.
Right. And, I mean, the way I would think people would still charge a nightly rate, and they would,
And it's up to them how they figure that out.
Right, right.
Maybe they get a break for
That's not
7
what I heard
days.
their complaints are.
What's that? Go ahead.
No, their complaints is that they want to be able to rent it 4 days here, and then the next 4 days, and then the next 4 days.
Yeah.
And not have that 3-day break because they got a 4-day renter here.
Right.
And so, changing the frequency does affect that. When we first mentioned.
No, it does. I just wanted to make sure that we knew exactly what it was and wasn't doing.
Yeah, that's what I say, I don't hear that's the complaint. We talked, what I remember, the discussion of 7 days, part of it is that it would get us back to more traditional rentals. That's where we started talking about it, is that it used to be a family would come up here and rent a place for the week. And that was kind of the impetus of where we started with that, at least that's my take on it. And without any concern about what the ramifications are as far as income for the individual. And then hopefully that would kind of push some of these weekend bachelor parties and whatever to the side. But from what I'm hearing out here, and I admit, I didn't think of it that way, it would impact the amount of income they're making on their business. Does it really affect the amount of changeover? Does it really affect the amount of problems we're going to have? Just because it's a different person in there every 4 days as opposed to every 7 days? I don't know.
Well, from what I remember, part of why we changed from 4 to 7 is it would reduce the number of changeovers for those people who are living around them.
The revolving door ones.
Right.
Not the ones that their intent was to just keep their family homes.
Right.
So in those problem areas, the enforcement and the education part of that, I think, is bigger than the 7-day part of it.
I think that you're talking about the enforcement, that is a big deal. But if somebody's staying 2 or 3 days, by the time somebody calls in, the people's already gone. So they say, well, that problem's gone. So then you bring the next. 7 days, if they start out with problems, hopefully you got somebody out there to take care of it before they're moved on. Because once they're moved on, I mean, they were saying there's no record of it or anything. I'm sure there isn't, because the people were gone by the time they got there. That's the problem that I foresee, where you're gonna have the problems of when they're there 2, 3 days. If they're there a week, chances are if you're gonna have the problem, you're gonna have somebody out there to take care of it.
Yeah.
Matt? Oh, sorry. We'll get him.
Yeah, this one I've kind of struggled with getting on board with. I don't really see a whole lot of value to making the change. I mean, 4 nights already is 4 times longer than a minimum stay at a hotel. So that's an improvement. 7 nights is a stretch, and I certainly understand that, the direct impact is going to be to inflict financial impact on the owners of these places, especially considering the short duration of the summer season. And I guess in kind of thinking this through, what could be kind of some of the unintended consequences of this is if we do have, good short-term rental hosts that are selective with who they pick, they may be a little more, a little less selective if they're limited to the amount of nights or the amount of times that they can rent out during a season, potentially.
Matt?
Well, just to Glenn's point, I was thinking that we really aren't, it's not the renter that's the problem that we are trying to regulate, it's the owner of the business.
The host.
So if we have a host that we get complaints from that, well, this guy was in there for 3 days and gone, and we can't deal with him, but what did the host do? That's what I see. And if we have a situation where we're getting a lot of complaints from the same place, it's the host, not just the renters. The renters are the problem for that night or two, but it's the host that's allowing it that's the problem as far as
Long-term.
long-term that we're dealing with. And there should be some kind of pretty punitive situation that way, once we get there.
I guess what strikes me is, I think the ultimate goal is the preservation of neighborhoods. I heard somebody mention that, and that really strikes a chord with me, having raised my children and my family here. And the courts in the state of Michigan have ruled this a commercial activity. And this is being allowed in residential neighborhoods. Now, do I think that it shouldn't be allowed at all? No, because guess what? We allow home-based businesses, okay? But what we do is we regulate those. And I think I look at this similarly, but I also don't think it's incumbent upon us to maximize their revenue. I think it is incumbent upon us to preserve neighborhoods. And so I do think that the less of the revolving door is more beneficial to the neighbors. So while I am supportive of 7-day and was back in 2019 when we changed it from 7 to 4 at the push of short-term rental owners, I'd be supportive of the 7 days. I do think that we should be respectful, I'm not sure if that's the right word, or acknowledge that there are people who have reservations in place and, and a year in advance. And so I think one person suggested if you do the 7-day frequency or the turnover, to set that in place in a year from now. And that sounds very reasonable to me. So those are my thoughts with it. I mentioned Mindy was supportive of the 7-day frequency as she was prior to this, so any direction or suggestion for Jake? Maybe Jake has a suggestion. Although I really think that's the board's policy decision and up to the board.
I still support going back. I've changed my mind. I was in support of the 7-day, but I think we had 4 days where we were before, and I guess why change it? I don't really see it changing that many of the situations, because it's the owner of the STR that's the problem more. And we got the biggest problem is that we have too many in certain areas, and very little about what we're doing tonight is going to change that in the near future. That's why, personally, I would prefer we would have done this through zoning, but I know there were reasons for it not done that way. But that's what zoning is for, so you can address certain zones in your township that are different.
Okay. All right, is that about clear as mud, Jake?
Yeah, crystal clear.
Okay. Okay. Those are pretty much the changes that, or the info that was changed in the ordinance. I do want to mention a couple things, suggestions I just noted here. Or someone had a question on trust too, but that still falls under the ownership and the change. Then you're going to take a look into that, correct?
That is correct. That is something we would look at when we look at the transfer.
And for clarifications, we can't fine someone for an invasive species or anything like that, but I just want to acknowledge that.
Yeah, and I think we already have some language about complying with maybe state restrictions pertaining to watercraft or something along those lines. But yeah, that to my knowledge, that's the purview of the state of Michigan, like the DNR, the DEQ.
Yeah, and also, you know, one of the ways that you fund to combat invasive species is special assessment districts. We all know that. We've sat through the classes. And a short-term rental would fall under that special assessment district. That wouldn't matter.
Right.
Okay. All right. And then one other thing, someone had mentioned limiting buses. And when I first heard that, I thought that was a great idea. And then I thought about it a little bit more. And then I realized, would I rather them taking a bus with a driver on it? Or would I rather them using several vehicles to transport more people and potentially have issues? I don't know. Any thoughts on that from board members?
I had kind of thought the same thing, but then I thought, I don't really want them coming from the winery, drunk, driving multiple cars. So I don't know that I have an answer for that. Maybe, I mean, it's something we probably wouldn't be able to enforce, but limiting the hours that the buses could come into the short-term rental, like buses can't pick up before 10 and can't drop off after 8, you know? I don't know if that's plausible, and I don't know how we'd enforce it.
Yeah, I think the enforcement on that one, it gets so detailed.
It would be really hard to do.
That would be very hard.
And I liked her suggestion too, though, about some traffic calming things. Just see if we can get some more stop signs down there.
Mm-hmm.
Because
Yeah.
I know that neighborhood, and she's exactly right. You can start at one end and just stop signs.
Lived there for 20 years.
Yeah,
I know.
So if we had just a stop sign or two in there that would,
Yeah, and I
of
don't
course, it creates
know.
more noise. I get it.
Yeah,
People
because they're
stopping
starting and
going.
stopping.
Well, and that's also,
But it eliminates the speed.
yeah, and we
Saves
can't,
the roundabout.
we can't determine that. The road commission has to determine that, yeah. Yeah.
Yes, we can also put the speed sign.
speed
And we do that, yep, yep. Okay, on to the notification and policy and issuance
Can I
policy.
just make a motion that we extend the meeting past 10 o'clock?
Sure.
I make a motion that we extend the meeting till 10:30.
Okay, is there a second?
I'll support.
Okay, motion made and supported. All in favor, say aye.
Aye.
Aye. Okay, any opposed?
Yes. I didn't have a second chance to say anything.
And then, let's see,
What number are you on?
we are on the, I don't know, the thing on mine, the,
Section number.
well, actually, it's the license notification and issuance policy. Yeah. Did anybody have any suggestions or changes on that? I only had one question, Jake, and maybe I wasn't reading it correctly, but under notice publication, the first sub-bullet point says, it'd be published in the newspaper, posted no later than 90 calendar days after an STR license or licenses becomes available. And then at the bottom of that page, it says that planning and zoning isn't required to notice licenses more than once per year. So,
Yeah, I think that 90-day language could probably be removed now that we're transitioning to
okay,
only advertising once annually.
okay.
So what we're saying is, if a license becomes available and somebody happens to call in and ask if there are licenses available, they could submit an application and get approved without anybody else in the township knowing? Is
No,
that-
no. What we're
So there would
saying is just once a year, they would basically end up noticing the bulk of licenses probably from that.
So we would only accept applications for permits or for license once a year?
We would only put the licenses available up once per year.
Okay, but
How are we doing the applications then? Keeping them in queue or having them during a set period of time?
It would only open once per year, and we would notice it ahead of time.
so no license would get approved except for that one time a year, even if they became open 6 months before that time of year.
Yeah, and part of that was just the staff time that would go into noticing in the paper, the opening of the license, that kind of the competitive review process. If, we go through that multi-month process, accept a license, and then we have another license available as soon as we finish that process, it seemed more efficient to do that. If we're only going to have a couple licenses available per year, to do it at one time.
So I'm just trying to think about how this actually works. So if a person sells their home to their child who can get a license, do they have to wait till that annual?
No, they keep the license that the parent had.
They keep the license, okay. Okay.
I think that could be an internal change to host compliance, just on the license holder, if it was a transfer to a family member.
Okay.
Or whomever the third-party vendor is.
So, and maybe to better explain how that 90-day language and the annual notice requirement would work, as presented, the policy, so let's say, 400,000 years from now, when a license becomes available, within 90 days of that license becoming available, then the township would be obligated to publish notice and establish the application window. Now, there's not really a set amount of time between the application window or when notice comes out in the application window. So if another license becomes available during that time, it can establish a new application window. But then once that happens and the application window opens, then the township doesn't have to notice again. So if after the application window closes, we accept applications, we give out the 1 or 2 permits that are available, and shortly after they're following it, another one becomes available, then we could wait until next year to do it again. So I guess the intent behind the 90-day language was to make sure that the township didn't sit too long on licenses. But if we just say that it has to be once a year, the 90-day language could be removed.
Two different things.
So
I think it gets to be too confusing. I mean, what about just between, January and March of every year, whatever licenses are available then? If they become available the October before, then they sit idle until the renewal period that we pick during the calendar year.
So we're taking out the 90 days. is what I heard originally from.
Originally, but then he was saying the 90 days hits for the first one.
Yeah.
And then ceases because we have the terminology in there that they don't have to do it more than once a year. But I think that's really confusing when you read
It is
it.
very confusing.
Yeah, so
It was not designed with once a year in mind, so it
Okay.
makes sense to change it.
okay, so
Yeah.
are you guys fine with once a year?
Here's my problem with once a year. So within the year, you have 2 licenses, and 25 applicants show up for that 2 licenses. Who makes that determination? First come, first serve?
It describes it in here.
Yeah.
It went into detail as far as like what time the applications came into host compliance and that stuff. And they only look at enough to fill the licenses available. So if there's 25 of them that come in within the 8 hours or whatever that it's open, the first 2 would get looked at for the license, the 2 licenses available.
So it's first come, first served.
Yeah.
Yeah. Yep, we talked a
It's much
little
like
bit.
housing for the MTA conference.
For the rooms.
Thankfully, we don't have to deal with that for the next 2 years.
Yep.
So is that annually going to be posted that way then?
And we also talked about having and I talked with Jake, and he recommended having this as part of our fee schedule, but have I would anticipate that some applicants might be less than 1,000 feet from the nearest,
Oh, right.
from the nearest short-term rental, or have deed restrictions or other barriers for us not to issue a license. And so we were planning to have, some processing fee, maybe $100, but not the full license.
Yeah.
But that
and
would be addressed in the fee schedule.
We had to do that in the beginning, remember? But we just haven't had to do that recently in, gosh, a number of years. So, yep, so you can, Jacob, that would be fine, we'll do it in the fee schedule?
Yeah, that'd be the appropriate place to do it.
So then are you, question on that, because I don't want to go back and do 25 refunds. That was a nightmare.
We can have them pay the original amount, the $100, and then upon determining that they're an applicant that would be approved, then they would have to submit the rest of the
So
fee.
is the $100 non-refundable?
Yeah.
Because that takes into consideration the time.
Right.
for administration.
That way you don't have to refund
Yeah, 'cause
25
that
people.
was a nightmare.
Yeah. That works, right, guys? Yep. Okay, good. Anything else on the policy? Okay, we will move on to the memo that discusses
Can I just ask a question?
Sure.
Realistically, does the board think we will be in a position to end the moratorium? We have until June 22nd. Or do we want to work towards extending it even another 3 months to get to this?
Jacob's going to give us a notification for an extension for next month in April. So we'll,
I know we also have other things on.
I'm sorry, an introduction.
For us to introduce that
Yeah.
next week.
Yep, we can introduce it on the 10th. Okay, so with that, we'll go on to the short-term rental license expiration policy options, and this talks about the recognition that we've, as Claire said, substantially changed the ramifications of not renewing a license. So previously, it was a lot like your driver's license, and if you were doing it like 30 days, I don't think that there's much of anything. You might pay a little bit more or something. But there wasn't a high hurdle to letting your renewal lapse and then getting that license back again, being relicensed. Now there is. Since we've set that level lower than our current license, and even if we set it just marginally higher, it still would be quite a bit different because there would be a level of competition for a small number of licenses. So with that, we've recognized that there's a big change in that, and that there are some people who were caught thinking, oh, I'm just not going to renew for maybe 3 months and maybe, get 15 months out of a 12-month period, or had some personal difficulties. I will say that staff has tried, and I give them props for this, with anyone who has had, and I think one of our speakers today at public comment was one of those, where we could go back and validate. We had not only technical issues, either on host compliance or our part, but really, that communication via email. Then we have worked with those individuals, and if it's documented, if they said, well, I paid for it, I just didn't get the email or whatever, if we could show that they had receipt for it or whatever, then yes, they did pay for it. We have not granted licenses where, because a lot of people remember that they tried and remember that they paid for it and they didn't. So we did not do that. We adhered to the moratorium, obviously, and the ordinance, but we did work with individuals very thoroughly in trying to establish that if they fell into that distinction where there was some type of an issue or an error that caused the non-renewal. So with that, though, there are a number of people, we talked to the board about this, about allowing some type of I don't know if you'd call it a grace period or did we name it some type of a window where we would allow the potential renewal for those people who didn't realize the intense ramifications. We talked about it staff-wise, and we went with a year before the moratorium, which would be June 21st of 2021 through 2022. But they would be given an opportunity, say like did we say 30 or 60-day window? 30-day window to renew. Those would be on top of and not, part of those would be additional numbers. One of the things that I'll mention is there are already rentals in existence, so to speak, and I did ask PT to go back and look at each one of those and make sure that we haven't had issues with renters on the property or the rental owners. And again, they'd have to adhere to everything as far as taxes are paid, no issues in blight, all of those good things. Anyway, we were able to parse out the data, and there are 22 of those. 22 of those, not 29. So when we took a look back at it, we realized there were 7 that had been sold, so it wouldn't be offered to them anyway. So it'd be 22. And then there were 2 in the queue that had everything in, and they just didn't have their CO yet. They were waiting for their CO. Right. Everything else had been submitted. They were waiting to submit their CO, and that deadline passed for the moratorium. Do you want to add anything to that, PT or Claire?
I would just add that it would likely have to be from the date, 30 days from the date the moratorium is lifted, if the board was to decide to offer a grace period, just because we can't allow any new licenses right now.
With the moratorium, you mean?
Because of the way the ordinance is written.
But these would be,
They'd be new.
would have been essentially
In the queue.
renewals.
Yeah, Jake, what's your input on that?
Yeah, I do tend to agree that unless the moratorium is amended, we'd need to wait until after it expires to issue those.
Okay. All right, so
Amended with verbiage to allow the 22 to be renewed?
Yeah, so unless we amended the moratorium to basically have some kind of waiver language or limitation to not apply to those permits, we would need to wait to issue them until the moratorium expires.
By the time you add the language to that, you might as well just wait until we're pretty close to the end. Although I will say if we end up doing the introduction next week, we could have the new moratorium have that language in it. Claire, were you going to add something?
That was all.
Okay. PT?
Can I just ask a question after PT?
You may go first.
Well, gee, thanks. So could this be taken care of with a resolution then, Jacob? Or does it, like we talked about with the 2.5%, could it be done with a resolution? I'm just thinking, if this is the direction we're going, these hosts want to be compliant, they have bookings potentially, and if they wait until our moratorium is over and then make their payment.
So I think, given the nature of the issue here, normally when you have something that is established in an ordinance but by resolution, that's something that needs to be revisited frequently and adjusted. So like fee schedules are a good example there, where there's going to be a fee charged for an application, but it's established by resolution because obviously fees need to go up and down over time. This seems to be kind of a singular policy decision that's only going to have to be made once. So I think it'd be more appropriate to put it in the ordinance.
Yeah, but we could put it in the new if we're doing another moratorium for, and obviously we're doing that just to kind of CYA because we're talking about what, probably a month or two gap we're looking at here, but we don't want that gap to happen. So we could put it in the new moratorium.
Yeah, it'd be very easy to put it in the new moratorium ordinance.
Yeah, I guess Glenn?
Question. How did this happen? How did somebody's license not get renewed?
Because they didn't renew it.
They what?
Because they didn't renew it. So.
Was that, what was, who was supposed to, was there somebody supposed to send them a notice? Or was it up to them to know when their license expired?
So you have a driver's license in your pocket that has an expiration date on it.
Now, you put it in your stupid phone and it'll tell you if that, was it up to the individual or was it?
No, it's always a personal responsibility. This is a license. I have an accreditation. You guys all have different accreditations. If I don't do my continuing education units by a certain day, the state of Michigan won't reissue my license, or my certification, rather. So it is obviously personal responsibility, but I will say specifically with this, if you were not paying attention to agendas, which I know there's a lot of people riveting on every word we're saying at home, watching us on YouTube, but a lot of people aren't aware of that. And so they weren't aware of the moratorium. Host compliance does email something out 30 days prior to the expiration of their license. And I know some people say, well, I didn't get that. And truth is, we've found a lot of people, it's in their spam. It's in that sort of thing. But we can verify no technical issues where someone would not have gotten that. We've gotten wrong emails, not updated emails, spam, but we haven't found anything where it wasn't sent.
Okay, how do we prevent this from happening again?
Well, I don't really think we're going to plan on doing a moratorium again, so.
No, I'm not talking about moratorium, I'm talking about where the people do get it renewed. Because did all of these run out during the moratorium? And they could have got them, I assume that they could have got them renewed even in a moratorium if they had the license already.
If they had, we've had renewals during the moratorium, that's allowed.
Yeah.
So if they renewed in time, yes. But the difference is these people didn't renew in time, but were under the false impression that there would be no real hurdle for them to get another license.
So that,
They didn't know about the moratorium.
no, they knew it ran out though, the license, and they didn't contact anybody.
Yes.
And when they finally got around to it, they found out there was moratorium and it had been expired too
Right.
long just to renew it.
Right.
Yep.
Okay, so we're not gonna fix that problem. Are we?
No, but we are fixing the problem that everyone understands the ramifications of not renewing. So to the extent that we set up a premise where it doesn't matter if you get the license now or I wait 2 months from now, there's a real change in that method or mechanism in which you would have the availability of licenses.
Yeah, because there's a finite number of licenses available. Before, there was infinite, like infinite, thank you. An infinite number. So there was nothing to say, oh, if I wait 2 months, that I wouldn't get it.
And if they're just seasonal rentals, it may not have been on their radar. Those that rent year-round, maybe it would have been. I don't know.
I mean, while this is the whole entire issue, one of the things that people have to realize what we're trying to do here is to create a community policy that is not necessarily and isn't made for one specific person. So this is going to impact people very differently. But what our job is, we're not afforded well, I don't know if I'd say it quite like that. So, oh, he's gone, the reporter, good, so he can't quote me.
Oh, yeah, but he's going to watch this and give an addendum.
Well, you can't, good, I forgot the quote. Anyway, you know the point that I was trying to make.
So so there's 22 that have been identified. 22 ex-hosts that want to get back in and sort of
Or
re-licensed.
20 and 2 that were in the
Not
queue.
necessarily that they want to, it would be, those are the number
20, that'd be
that
22.
would have the opportunity to. Some of them might have no interest in renewing.
Not all of them
So-
have reached out.
So this has been since June of last year, basically, somewhere in that time frame. So that's what, nine months or so.
And the
What-
board can choose, we just chose a year because we thought, well, if we're going to examine this, we want to be as inclusive as possible. The board can always choose to make it a narrower window, but we wanted to do the analysis so that we knew exactly how many we were talking about.
Well, I guess my question is, have these units just been sitting vacant? Is there 22 vacant units out there? No? Have they been renting
Some of them have, yes.
out of compliance?
That is correct.
That kind of even makes a bad situation worse.
And some have not. I mean, we
Some have
haven't.
not. Yep, that's correct.
Okay.
It's really a mixed bag, just like it's a mixed bag of why didn't they renew? Some forgot, some were trying to just eke out more time, some were trying to decide what they were going to do. It is a little bit of a mixed bag. Glenn?
Okay, something to clarify. 22 of these aren't the people that sat in here that want their license renewed.
Yeah. Some are.
No, I said the whole 22 aren't. Is that what I heard?
That's correct.
Yeah.
Okay, how many actually, was it the 6 that wanted them renewed?
So, and that's what I was going to speak to, Matt. That's the difference between February and tonight, is that I'd had many phone conversations with, well, not many. I had some intense phone conversations with some residents that came to the total of about 6. That's why I quoted that number in February. I've identified actually 9 that have reached out and expressed their concerns and their desire to renew, that didn't renew because the moratorium was in place, or couldn't renew, I should say. because
Well,
the
there's
moratorium-
some I'm wondering would be on that list, like, I'm trying to think of the name, Bransky was on the list, but I don't know if he reached out to you, but he had written a letter to us and to the board.
Okay.
So I'm not sure if that would hit that list.
Okay.
Do you recognize that name? Okay.
Yeah.
Oh, okay, okay.
What we're being asked to do is approve 22 when 9 are the active ones. This will give the remainder of them open to people to get?
No, you're not being asked to authorize 22 licenses. You're being asked to give the opportunity to 22 to potentially renew.
Okay, these are renewed, this isn't new people. If the people don't want
That's
to
right.
renew, we're not bumping our
We're-
number back up
No,
to add more.
no.
Okay, that's one question. Second one, you mentioned about, you got 2 licenses where people did all their paperwork and they didn't have their CO. In other words, they're building a house and it wasn't done. When did they do the paperwork? When they started the house?
No. So even though we didn't advertise a moratorium, word got around that there was a door that was shutting. And so, I don't know, maybe 3 weeks prior to the 22nd of June of last year, we were getting bombarded with new licenses. These 2 that are in the queue were of those 2 that heard that the door was going to shut and wanted to get in before the moratorium went into effect.
Okay. And when did they get their CO, or haven't they yet?
They both have. The exact date, Glenn, I don't know.
I mean, are we talking 6 months down the road, or was it fairly close?
I know one was, well, actually, both of them were fairly close, yeah.
Okay.
Within a couple months, I think, actually.
Okay. I do know I was going with that other point, which is while we're trying to create like a policy that is not tailored for one specific need, but for the community. And so with some of that, some people will like that we're picking one characteristic of this ordinance and being proponents of it. They might not like another one. And this is one of those cases where, I am supportive of giving those the opportunity to do that, just because to me, the game changed so drastically. Only I'm open to, if you think that year-long window is too long, then we'll shorten that. But I do think it's fair because the ramifications were pretty great.
So is it fair to ask the question of our planning and zoning department, are any of those 22 plus 2 in our problem areas? Are we going to be adding active?
Well, but the thing is, they were active.
Yeah.
Short-term rentals, and that's one of the reasons that I think, that's one of the things that I was thinking about. It's like, we're not adding something new here. These were rentals that had no
Went through and they
issues.
had no issues. They were not you weren't receiving complaints for them.
Well, and I don't think you can pick
Yeah, I
those
know,
out just
I know.
because.
I'm just thinking of
Yeah.
Pine Grove,
Yeah.
you know?
I don't think we can do that. That would be like,
I had to ask.
you can have it and you
10:28.
can't.
Well, I guess I'm still confused as where the other 13 after the 9. The 2 I understand.
Okay,
But the 13, you had 9 out of the 22 that had a license and they didn't get it renewed. So what's the other 13?
No, they're all in that boat. It's just that 9 contacted him. 13, we haven't heard from
And
specifically.
of those 13, Glenn, I mean, hypothetically, 100% of those may not want to renew, and that's why they didn't. We just haven't heard from them, so we don't really know.
Okay, but that isn't going to open up 13 licenses.
No.
Okay.
No, sir, no.
That's all I was trying to get
Yeah.
through my thick skull.
We just wanted an equity between people that approach the township, and then we, figured maybe there's some that did want a license, but didn't approach the township or didn't vocalize that, and we just wanted equity and
Yeah.
treatment.
Yeah.
So are we at a spot where we can do a motion?
Yeah, I think we are.
I'll give it a wing.
Okay.
All right.
Go ahead.
Go ahead,
I-
Matt.
On this particular topic, I will say that I know this is a very unique situation that we're in with or at least unique to this township for right now. I know it's pretty commonplace a lot of places, but this particular issue with the licenses kind of not making it through. But that being said, there's been a lot of conversation about short-term rentals for a while now, even leading up to the moratorium. And I can't think of any other situation where we would, open the door of possibility to someone that wasn't compliant with something. Sometimes when those decisions are made and doors close and whatever it may be, some big issue in the community, a rezoning or something, and somebody says, well, I didn't know that was happening. I didn't know that was happening. We wouldn't open the door back for those individuals to come back and have a seat at the table. That decision's been made and that time has passed and we've moved on. So, I get the need to, have some type of fair process here, and maybe I'm not being fair enough, but I don't know. It just seems like we're maybe bending the rules a little bit, in this particular case. And that being said, I also don't. If we're going to make a motion and decide what this number is, I don't, personally think with all of the activity that's been around, all of the press around this particular issue in this township for, the past 9 months, if there's 13 people out there that never really reached out to contact us again, I don't think we should, volunteer that.
Well, are we going to contact them now?
Yeah.
Yeah, that's what
it
we
sounds
would,
like.
that's what we would do, is give them the opportunity within 30 days to renew that. No, I respect that opinion. I mean, I would have fault with nobody who said, I just don't want to offer them at all, because it was incumbent upon them to renew it. And that is true. I guess I've just seen where, we did the moratorium, and yes, the press had a hold of it, but I think if we had a moratorium to do again, I would give better, further advance notice of a moratorium.
Well, yeah.
We have never done a moratorium in East Bay before.
But then in this particular case, you're also shooting yourself in the foot because you're defeating the purpose of the moratorium. You say, hey, 30 days, we're going to have a moratorium where you're going to get a rush of people in here applying for licenses. So it's kind of a self-defeating.
Well, I think we were saying the moratorium is for new licenses. These are not new licenses. These would have been renewals. They were existing licenses. These aren't houses where.
Yeah, I get that.
And more likely, I'm guessing, but probably quite accurately, is that this is what the majority of these are probably the ones that are the legacy homes. And they don't live here anymore, but it's been the family homes forever. And so they're maybe not getting our local news. Maybe they weren't, but maybe are now receiving our subscription to our website so they can keep track of things. I don't know. We can assume a lot of things, but irregardless of that.
Yeah.
That it doesn't appear to be that they are the corporations that went in and gobbled up 20 licenses a year before the moratorium went into place, with no intent of ever having them be, they weren't an organization of a business that way. They were probably single homes.
Yeah.
I don't know.
Yeah. Well, I mean, what level of enforcement is taking place for, current STRs that are out of compliance without an active license that are renting? I mean, that I have a lot of issue with, especially with all the conversation around enforcement. The fact that someone does not have a license and is actively renting, just.
Okay, so
Yeah.
to speak to that, the process that Claire had mentioned earlier about whittling down what constitutes a dwelling that would require a short-term rental license and what wouldn't,
Yeah.
that took some time. It took some time, it was more time with our host compliance than it was with the third party that whittled down stuff for us. Once we finally got those numbers accurate and down, there was the same week, host compliance sent out the first letter notifying them to cease and desist. That is a 30-day window, roughly, and then a second round of letters go out saying that you have been identified as a property that is not in compliance, you do not have a license, and then it notes the fine, which is $500 per day that a rental occurs. And once that window of time passes, citations will start being issued.
And that fine, that $500 a day, that first notification has already gone out?
It has.
It's active right now?
It is, and although I don't know the exact number, Matt, I remember mentioning this to Claire, that between February and March, we get that monthly update. There was roughly 15 to 20 less non-compliant, identified non-compliant properties than in February before the letters went out.
Did you mention that we've cleaned up that database?
That's what I'm
Okay,
talking about.
okay,
first,
yeah. Okay. Okay, is there a direction on the window of those licenses?
Well, I was going to try to articulate a motion. I will give it another shot. I make a motion that we advise our planning and zoning to contact the 22 short-term owners and 22 waiting in the queue owners of our two, for a total of 24. I'll start again. The planning and zoning provide correspondence, notify the 22 short-term rental hosts of our intention, along with the two, I was going to do it again, waiting, that were in the queue waiting for their occupancy permit, that we will allow them with a fee to apply within 30 days after the moratorium is lifted.
Well, why don't you say within the moratorium language?
Within the moratorium language as being directed.
Right.
Can
Go
you
ahead.
clean that up enough to make it sound right?
I don't know, is that fine, Jake?
Does that make sense, Jake?
I think I understand the direction I'm being given.
So ultimately, the 22 plus 2, the 22 that were previously licensed, but for whatever reason did not relicense, would be notified of our action, our intent to allow them to reapply or to put their application back in, plus the 2 that were in the queue waiting for their occupancy, to let them know that we will allow them with a penalty to apply within the parameters of our moratorium.
Okay, I understand that, and I will also amend the moratorium language accordingly.
Thank you.
Okay, is there support?
I'll support it, then I have a question.
Okay, I have a comment. One, I would be, while I'm generally supportive of the motion, I'm not in favor of the 2 that are in queue because those are new licenses, and so I don't know where they fall. But anyway, you had a comment and you had a comment, so I'm gonna let Matt go and then you.
Yeah, I'm still hung up on the number, which would be the 9 that have been actively having conversations about being, having interest in this. Also, there's a recommendation of the 30-day deadline for the renewals, but we're essentially with the moratorium going to be given a very extended window.
No, they'll only have the 30 days from the second renewal of the moratorium language.
Well, I guess once this meeting is public, people know that now the door is open again, and
True
they'll
enough.
have however long until the moratorium, plus maybe another 30 dads to get through the.
But not as a new license, for those that had a license that needed to be renewed. So it's not opening up additional new licenses.
It's only going to be the 22 that we've identified.
Right.
Anybody that calls tomorrow isn't going to be on
They're
that
not new
list.
licenses.
Or are they? Because we've talked about a one-year period.
No.
Well, I don't think they would be, Matt.
No.
We did our due diligence,
Okay.
diving through what was there and,
Good.
yep, in that window of time.
Tracy?
You mentioned with a fee, I don't know what that is.
And, well, and it just says that it is advisable to require a penalty fee to help cover the additional staff time associated.
Yeah,
There-
but
the
we didn't
Staff did
identify.
not give us a fee number.
And then,
My Excel skills are priceless. What can I tell? No, go ahead.
and then oh, sorry, I just got really dizzy. Then the 2 licenses that were in the queue that needed their CFOs, that's included in your approval.
It was included in my
So
motion.
that's I mean, again, they purchased their homes with the understanding that they could have a license and there wasn't a deadline. And so and they've
That's
come
why I
forth. I mean,
included
they
them.
were right there when we were putting the
Yeah.
moratorium in place. So I think those are valid to be issued, even though they are new licenses.
That's
They
why
were
I.
building the homes, I think, weren't they, 2 of them?
One was
One was a
renovated.
renovation, one was a build.
Yeah.
Both have been in correspondence with me basically right from the start. One, it's almost weekly, it's continued weekly, corresponding with me about it for
We
any
know
updates.
his number.
Well, it shows that they still have an intent to comply,
Yep.
to see it through.
So
Okay.
I think we need a dollar figure if we're putting a fee on this.
Jake, can you include that dollar figure in that?
A
Can we
reasonable
establish it
dollar
through that?
figure.
Yeah, that can be in the moratorium.
Yeah,
So what
that
is
sounds
that?
good.
$100.
Yeah, I would recommend the $100 if that's our processing fee. So the $100.
On top of their regular.
$400 for the license.
So it'd be 500, okay.
Okay, motion has been made by S. Cortade and supported by Bartlett. Further discussion? Okay, all those in favor indicate by saying aye.
Aye.
Opposed by no?
No.
Okay, let Cook show, did you vote yes?
I already voted.
Okay, you voted yeah, okay. So let the record show that Cook dissented. And, wow, I think we're through short-term rentals for the evening. So thank you, everyone, for sticking through with us on that. We'll move
We
forward.
still have one item, so be
Yep.
quiet when you
If you
leave,
could,
please.
the meeting's not over, so, I mean, you're welcome to leave. We're not holding you captive. You're welcome to stay. But just if you could, just leave quietly so we can
But we do need a
communicate.
motion to extend the meeting again. if
We're,
we're doing it.
nobody's gotten up and left yet, so I think we're good. Let's, East Bay Ambulance, we've got on here, a motion to approve. Bye, Jake.
Thank you.
Take care, thank you. We have a motion to approve the hiring of Daniel Cunningham as presented with the offer of employment. Talked with Nick, and he has nothing but glowing things to say about Daniel, and that we would be very lucky to have him on board.
I just had a comment. The letter to Daniel says the 10th of April.
I think
And
that's when he
that needs-
expected it was
yeah.
going to be.
Yeah.
So we just need to make sure we fix that. I would make a
The
motion.
letter to Daniel says the 10th of April.
Yeah, because
Yeah,
that's when Nick's
the-
offer was going to be presented.
The March 30th letter,
Oh, that's right, yep. Yep.
I would make a motion to approve the hiring of Daniel Cunningham as presented.
Support.
Okay, motion is made by Bartlett and supported by S. Cortade. All those in favor indicate by saying aye.
Aye.
Aye. Opposed by no. Okay, we'll let him know that tomorrow. Yeah, we thought we would just, let him know because he wanted to be able to make his plans. Let's see, what have we got? The job description for the part-time building and groundskeeper.
And I'd like to make a motion that we move that to the next meeting.
Okay, the only thing is, I do have some RFPs to go out, and we're already on a short window for the RFPs. So the RFPs have to do with the janitorial services that would be needed in the Parks Commission and the lawn services.
But
Yeah.
isn't Monday basically a reports meeting? Can't we just add it to Monday's meeting?
We can, yeah.
Because it's a holiday weekend. I mean.
Yeah, we can add it to next Monday. I mean,
I would add it to Monday.
okay, that's fine.
I mean, I don't have a problem with it, but it sounds like there needs to be some discussion, so.
Okay, that's fine. With that, we will have public comment. Any public comment?
Lisa Davidson, when you talk, you need to talk into the microphone. You are very, very difficult to understand.
Okay, thank you. Mr. Ralph, how are you?
Ralph, or Preston?
It's you have been.
Feel like I should be an employee. Ralph
We're not getting
Bednar's,
any extras.
Ralph Bednar's East Bay Township resident on Rennie Lake and president of Rennie Lake Association. Again, I'm tired, so I'm not sure if I can articulate this correctly, but based on Supervisor Friend's comments concerning my previous comments, I feel that something was missed. The main purpose of my comment was to indicate that that short-term rental properties are an avenue for public boat access to the lakes. AIS is a potential consequence of that. But the point is that these are avenues for allowing public boats to access the lakes. Now, I may not be correct in this, but I think of the 14 lakes in the Forest Lakes area, only 3 have public access facilities on them. So the other 11 lakes are quote-unquote, I hate to use the term private because they're not totally private because they're state land, but they don't have public boat facilities on them. So what you're doing without any controls on these short-term rental properties that do have access to the lake, that's the avenue for public access, which is not available on many of these lakes. That's my point. It's the same point I raised with the Gorik situation. And so that's where I'm at on that.
Okay, and I just wanted you to know, because I thought you mentioned a fine for them.
No,
And I
didn't
just,
mean a fine. I said a surety fine, in case
Yeah.
they are the culprits of
Yeah.
infestation.
yeah, and I just wanted
And
you,
then you discounted that by saying that, well, we learned in our classes that that's taken care of by special assessment districts. A
No,
special
sir.
assessment district puts the burden of the mitigation costs on the riparian property owners, because that's a taxing authority for riparian property owners and backlot properties.
it's not a taxing authority, but
It's an assessment.
it's an assessment, but
I do back and forth.
I-
Talk afterwards.
excuse me, I'm the chair. I will take care of
So I
this.
just want to clarify that.
What I
And
just,
also, I want to clarify that, I think the statement was made, and your attorney's not on here anymore, but that the state is responsible for the control of AS. If you're going to wait for the state to be the responsible party for AS control, that's going to be a lot longer than coming to the 145 number for your moratorium and rentals. The state's not going to control AS. We all know that. It's really a local issue, and I would recommend seriously that this board takes up the potential of putting together an AS ordinance for the Forest Lakes area. Thank you.
thank you. Good night. Hello, how are you?
Oh, pretty good, a little tired, but I understand that short-term rentals are a contentious issue, and I commend this board for not only having a lot of public comment, but having well-reasoned and deliberative discussions on this, and recognizing that after 4+ hours, a meeting becomes a little less efficient, so maybe the last few items should go on to a subsequent meeting.
Thank you, Mitch. Have a good evening. Hello.
I want to ask a question on that, on the short-term rentals. You talked about people who will get the new license. Are you going to limit how many are in that area? And
So when,
the Pine Grove area, where we have a lot, and say you have some license that come up.
So let me just, because you're asking for feedback, let me just have you direct your question to staff, who can answer that afterwards versus public comment.
Okay.
Okay.
Yeah, I got just kind of clarify what
Yep.
you were trying to say, and I kept thinking, I wish they would be more clear on what they mean by that.
I understand. Thank you. Okay, and with that, if there's no objections, we stand adjourned. Have a good evening, everybody.